Application number 5056 of the 15.
So we have remanded you to consideration and laid down the parameters what should be.
Deeply applied.
Item 2.
Some minor corrections are there. Maybe you'll be on Monday.
WC 6000 of the 23.
Loud.
Nice.
C2. WPC number 6008 of the 21.
Dismissed.
Delivery of orders, item 3.
Allowed, but we have made certain observations. And we have asked them to recalculate what is, because it is not only the salary. So we have laid down certain parameters. In terms of that, they will have to do calculation on the recovered amount.
Yes.
Because it is, there are some other also. So they will have to make calculation. What you are entitled, you have said,
Yes, Lordship.
salary and
Basic
DA,
pay.
basic pay, and others we are not giving.
Yes.
Yes.
Item 4.
We have relegated you to the appellate authority, holding that this court is not an appellate court under 31. Arbitration. So, yes.
Item 5.
Where is Gogoi?
Lordship, can you allow me to call him? Lordship, he might be away.
Your Lordship, I'm appearing for the petition on item 5.
Just tell us what will be your argument as regards waiver.
In
5. Till 5 is conditioned subject to waiver. Will
Correct.
it not be an waiver? Suppose we hold that it is an they cannot do it.
Your Lordship,
By virtue of the act itself, it has been said that those who cannot appoint, he cannot be the arbitrator also. Okay.
correct.
Uphold the judgment and interpret core that no, it will not be applicable. Now, what will be your reply to the condition of the statute itself that this is an waiver?
Your Lordship, in my humble submission, there is no waiver in our case.
Why not? Will the signing of the agreement after coming into effect of the act will not amount to waiver?
Your Lordship, in my humble submission, it will not amount to a waiver because the waiver clause is in the form of a proviso. Here there is no waiver because neither parties have waived any rights expressly to not have their disputes adjudicated through arbitration.
What will be the procedure and mode and manner of waiver?
Your Lordship, if Your Lordship may give me 30 seconds, I will just take out the provision and I will be able to assist Your Lordships
Yes.
better in that regard. Right. Is your Lordships referring to section 12 subclause 5?
5 proviso.
Proviso, provided that the
Yes.
parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement. There is no such agreement in this particular, in my view, in my understanding, there is no waiver happening in the facts. The waiver clause, the proviso, is applicable only when the parties have an agreement in writing, and by virtue of that express agreement, they have expressly waived the applicability of 12.5 altogether. There is no such agreement in place, Your Lordships.
See, the clause itself in the arbitration clause itself is in derogation of the section 12 subsection 5. Isn't it? a clause pursuant to amendment of 12.5 and incorporation of schedule 7. On the face of it, that agreement is not valid. Okay, now there is a proviso to that section that parties can expressly waive it.
Correct,
So
correct.
there is an incorporation in the agreement itself that this will be the clause. You have signed it. Will it not mean a waiver?
Your
Is
Lordship,
it not an express?
Your Lordship, in my humble submission, it may not amount to a waiver because the agreement provides for two situations. 64(3)(b) says appointment of the arbitrator where applicability of 12.5 has not been waived off. And 64(3)(a) talks about a situation where the applicability of section 12.5 has been waived off. Now, because the principal act talks about a waiver, what the agreement does, in my view, is essentially provides two options to the parties.
Because on the signing of the agreement, you have not said that this clause is bad for the violation of the provisions of section 12 subsection 5. And section 12 subsection 5 itself says that parties can waive by expressly. Will
Correct.
it not an express agreement between the parties that we are accepting arbitration clause which is beyond scope of beyond section 12.5?
Your Lordship, with the utmost amount of respect, I will have to disagree with what is falling from your Lordships, because the requirement in 12.5 firstly is an express agreement that we will not follow the rigors of 12.5, and 12.5 incorporates schedule 7. So in order for the applicability of the proviso to kick in, there has to be an express agreement whereby the parties have agreed that they will not adhere to the prescriptions.
So according to you, the signing of the agreement which includes the arbitration clause in derogation of the subsection 5 of section 12 read with schedule 7, though we have signed it, this is not an express agreement to the arbitration clause.
Your Lordship, according to me, there is no express derogation of 12.5 happening. The signing of the arbitration agreement here does not mean that there is any derogation to 12.5, because the arbitration agreement talks of two situations. There is a difference between the arbitration agreement providing these two options and the parties following what they want to follow. What I basically mean to say is, if the parties wanted to waive off the applicability, there would have had been a subsequent agreement after the signing of the agreement whereby they would have expressly stated that
Any
we don't want
authority
to
in this
follow
regard?
12.5.
Any authority in this regard?
Your Lordship, I don't have any authority in this regard at the top of my head.
So you take it down, 2019 5 SCC 755. This is from my side.
No, but I follow.
Okay, now tell us.
completely-
Okay, we understood. Yes,
Okay.
now tell us who will be the arbitrator.
Your Lordships, we have proposed the name of Justice B.P. Kotoki. If the respondent has no objection,
Yes,
Your
Gogoi.
Lordship may appoint him straight away.
Otherwise, Lordship, we are bound by the DCC Lordship. So, Lordship, for a moment, kindly peruse DCC Lordship.
No, we have Paris GCC.
Just-
Law is
just-
well said. We have decided our part.
Just as I have clarified one thing, Lordship.
Yes.
Regarding, I have
Your core judgment, we have distinguished.
court judgment, not Lordship. Not only court judgment, Lordship. I have regarding the party Lordship. Party Lordship. The particular demand should be by the parties Lordship. Arbitration demand Lordship. So, Lordship.
You are insisting on parties. Okay,
Party.
that paragraph will write.
For that part, I have just clarified one thing, Lordship.
Yes,
So, Lordship, may kindly peruse page 64. For a moment, Lordship.
page 64.
Page 64 by DCC Lordship.
Are you referring to page 64 of the record, opposing counsel?
File.
File.
Page
Page 64.
of the petition.
Lordship.
Yes, page 64.
No, page 64, Lordship.
Hmm.
64, 1, Lordship, page 64, Lordship, the relevant portion, Lordship. First paragraph, Lordship, in clause 63.1, Lordship.
63.
3.1, 64, Lordship.
Page 64
Page
starts with
64, first paragraph, last 3 lines, Lordship. That's the relevant portion, Lordship.
okay, clause 63.
Clause 63(1) of this condition, the contractor after 120 days, but within 180 days of his presentation of his final claim on disposal matter, shall demand in writing the dispute between and differences and refer to the arbitration.
Okay.
It says that it is a express provisions in the GCC law, it should be by the contractor.
Mm.
And regarding our claim, our letter also, just we have lordship replied them, page 99 lordship. Page 99 lordship.
Page 99.
Page 99 lordship.
Okay.
Accordingly, it's a letter issued by the against the attorneys. We have replied lordship.
Mm.
Accordingly, it is advised that your client.
Mm.
My lord, page 99.
Huh.
Accordingly, it is advised that your client, either contractor of the contract agreement,
Mm.
may approach and demand for arbitration to the general manager so and so. And it was also stated in our affidavit in paragraph lordship.
Mm.
It is only, 11 and 13 lordship.
Paragraph.
Paragraph 11 and 13 lordship.
Okay.
11 and 13. And for that purpose, lordship, we have to read the lordship, the sections of arbitration conjointly, 21 and lordship, other 11, section 11 also lordship,
Section 11.
11
and,
laws.
and
21 lordship.
what is that? Arbitration.
Arbitration act lordship.
Yes.
Lordship, may I point out lordship? Section 21 says that lordship, commencement of arbitral proceeding lordship.
Mm.
For appointment of the arbitrator by the honorable court lordship,
Mm.
we have to conjointly read the provisions of definition clause of section 2H lordship,
2H.
section 2H
Mm.
and lordship,
Mm.
section 11 lordship, and section 21 lordship.
Section, just a minute.
Lordship 2H. Our GCC is very specific. GCC says that it should be by the contractor. Our reply also says that the party to the contract agreement lordship. 2H lordship. 2H, definition clause 2H lordship.
It's party.
Party means a party on an arbitration agreement.
Okay. Mm.
The party, one is the Pius
Okay.
Traders lordship, other is lordship.
Okay.
Then
Then
lordship,
section.
section 11 lordship. Section 11 says that lordship, 11(4) lordship.
Mm.
Regarding lordship, where Chief Justice of the concerned High Court and now lordship it is vested to the my lords also lordship,
Mm.
the fulfillment is 4 lordship, 4.
4.
If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator, my lord may kindly mark it.
Within 30 days.
My lord may kindly mark it, a
So-
party fails.
So from the other party.
So from the
Party
other party.
fails from the other party.
Other party, and party defines that the party should be the contractor.
Mm.
Particular agreement, it should be the, and that was also lordship in the honorable Supreme Court judgment.
Mm.
I am relying lordship.
Last occasion you realize.
Last 2012 9 SCC 496.
Okay.
It says that
Mm.
it should be the party of the contract, not a attorney, not a advocate. If power is given also, it cannot
Give
be.
the judgment.
2012 9 lordship, I have already given copy.
Just read it.
2012 9 SCC
That is
496.
there. Just a minute. 2000.
2012 9 STC
1000. To 11 SCC 321.
no lordship 2012 9 STC 496.
It is not there. Others are there. Just tell me. I'll take it out.
Lordship, I'll hand over the copy.
2012.
2012 9 STC 496. Just
49.
I am reading and hand over it lordship.
Yes.
Right, reading lordship.
Paragraph
Paragraph lordship 15
15.
lordship.
Hmm.
Paragraph 15 to 17 lordship.
15 to 17. Yes.
Just I point out relevant part lordship.
Hmm.
Paragraph 17 lordship. The expression of party as defined in section 21H of the 1996 Act
Hmm.
clearly indicates a person who is a party to an arbitration agreement lordship.
Hmm.
The said definition is not qualified in any way so as to include the agent of a party to such agreement
Mm.
Any reference thereof made in section 31(5) and 34(2), here in our case, Lordship, 21 and 11,
Mm.
section 11, Lordship, of 1996 Act can only mean the party himself, not his or her agent or advocate empowered to act on the basis of the Wakalanama. In such circumstances, proper compliance with section so and so, and would mean, and not on his advocate, which is gives a party concerned to the right to proceed. So, Lordship,
Mm.
my humble submission before your Lordships that
Mm.
the requisition or the applications which are
So according to you, this is premature.
premature, he has to fulfill first condition, Lordship.
Mm.
Even today also, Piyush Traders applied for arbitration, Lordship, for his contractor, we have no objection.
Mm.
And we have reiterated our affidavit also, when they have demand to attorney, then also we have says that as part of GCC, contractor is the party who have to apply, you apply through your concerned contractor,
Okay.
party to the agreement. Even Lordship, the act also says that
Mm.
party means the party to the
So
contract.
therefore, when there is no demand from the party
Party-
itself, our will cannot assume power
Lordship,
under section 8.
Lordship. Even GCC also, Lordship, very specific.
Just
GCC also very specific, Lordship. And my lord may also see the demand.
Mm.
What is the demand? Demand says that the railway authority cannot act upon the as part of GCC 63.4, Lordship. This is their demand, Lordship. My lord may kindly peruse the demand letter, which was sent by the attorney, Lordship. All is about the, Lordship, that waiver part and the GCC, Lordship. The railway cannot appoint, Lordship. Page 90, Lordship.
page 90.
Page 90, Lordship. 90, Lordship, my lord may subject, my lord may kindly peruse the subject. What is their demand, Lordship? And Lordship, the first letter after dear sir, Lordship, I write for and under instruction of my client, Lordship. We have to done the act as per the statute, Lordship. The golden principles of law which was laid down by the Honorable Privy Council in the Lordship Nazir Ahmed case, and which was reiterated time to time, lastly in the Mohan Singh case, Lordship. It should be by the act should be done by the as per the statute, Lordship, not beyond that. The statute also says that party himself, party is the contractor, and GCC also says that. GCC also says that it's by the party, Lordship. Even, Lordship, the last
Okay.
even, Lordship, in the Mohinder Singh case,
Your Lordship, can I quickly respond to this super quickly?
even, Lordship, Mohinder Singh's case,
Mm.
Honorable Supreme Court says that you have to done as per the statute. Even, Lordship, if one advertisement is issued, Lordship,
Mm.
one advertisement is issued, Lordship, we one candidate applied the post for a particular post, Lordship, as per the advertisement, then it should be done as per the procedure laid down by the
Of
advertisement.
course, there is no doubt.
That was also reiterated in the Mohinder
Yes,
Singh
what,
case,
how
Lordship.
do you respond to it?
Your Lordship, our lawyers will lose their jobs effectively if the interpretation given by the opposing counsel has to be resorted to. My simple answer is this. The notice invoking arbitration has been sent under Section 21 of the Arbitration Act, read with a certain provision of the contract, which entitles the party, duly represented by an advocate, to file the claim. Their notice, their reply, which was sent thereafter on 30 December, which starts at page 100, does not deal with any of this, which is now being argued by the opposing counsel. The fact that the letter should have been addressed by Piyush Traders in their personal capacity and not through their advocate is something they should have addressed straight away in their response if they wanted to do so. It clearly shows it's an afterthought. The judgment that is being cited, a 96 judgment, presupposes, in my view, that judgment is distinguishable because in that judgment, the word used is vakalatnama, which essentially means that that judgment is not applicable for the notice stage. At best, that judgment could be applicable for a stage after notice has been issued and the proceedings have commenced. But for the purpose of issuing a notice, there is absolutely no bar in a party giving that right to a lawyer, because let's understand the basics of Section 21. A party is not going to be able to understand the requirements of Section 21 of the Arbitration Act. It is a lawyer who does that. So the law cannot a judgment can't be read in a manner that is going to disentitle a party of its own benefits. Let's assume today Piyush traders were to send this notice without being properly instructed by a council. Piyush traders can't be expected to know the rigors of 21. Piyush traders can't be expected to know what is going to happen after a notice is being sent. So if you eliminate an advocate at this particular stage, then it becomes very easy for them to come up and say the requirement of 21 is not fulfilled. His argument is nothing, a hollow argument and an afterthought. And my last submission is that insofar as the argument on waiver is concerned, your lordships, I would like to go back to that argument. There is the question of waiver here is inapplicable because there is no agreement.
CAB,
Lordship, with regard to the argument, Lordship will kindly come to page 98, your Lordship.
98,
Your Lordship.
what is that?
Addressed by the Chief Workshop Engineer, Lordship, addressed to Mr. Rangwan, the Advocate, Lordship.
Huh.
The content of the letter states that they have understood the content thereof.
They have,
Understood the
Mr.
context there,
Mr.
Lordship.
Attorney has sent a letter, so we have replied to attorney.
His Lordship, it appears that
Okay,
the
okay.
parties has understood, your Lordship.
Enough, ho gaya.
Oblige, your lordship.
Your lordship, is your lordship delivering the judgment today, or would your lordship be pronouncing?
Because the additional arguments are advanced, you'll have to address this, it's a CAB, otherwise you were supposed to deliver this judgment today, CAB.
Oblige, your lordship. Oblige.
We will have to address that part, that is not.
Oblige, your lordship. Obliged.
Mr. Goswami. Anything, anything? Have been able to communicate?
We have communicated. Here.
Yes,
Lordship, matter may be kindly passed over for timing, Lordship.
okay, fine. Yes, mention. Mention.
With the consent of the petitioner's consent, I beg to mention item number 21.
20.
21, my lord.
Hmm.
Lord, in this matter, instructions were received yesterday only, my lord. 2 weeks time may be given to file a petition.
Okay, wait for some time. Why this 22, 23, 24 are tagged?
These are wrongly tagged, my lord.
So we'll
Yes.
take up this matter when this is listed.
My lord, item number 17, my lord, additional affidavit already filed by me, but the same is not on record.
Hmm.
It may be requisition, my lord.
Yes,
May I please, your Lordship, I'd like to mention item number 61, Lordship.
item number
61.
supplementary or what?
No, main list, your Lordship.
Yes,
Your Lordship, as per the instruction of client, this matter may withdrawn, Lordship.
you are Mr.
That's right.
Astroy Learned Counsel for the petitioner submits that his instruction to seek withdrawal of this petition. Accordingly, this petition stands closed, dismissed on withdrawal.
Your Lordship, another prayer in item number 34, your Lordship. Land Council, Mr. MS Lordship is out of session and he has submitted the letter of absence, your Lordship. So, any day on the next week, your Lordship.
Okay. That is desealed.
Your Lordship,
Okay, you will manage. Okay. On the prayer of the learned counsel for the petitioner. Item number 34,
34, your Lordship.
matter stands adjourned and be listed after 3 weeks.
Your Lordship, maybe exported, your Lordship.
Yes, next case.
Lordship, I'd like to mention item number 45. Order has been complied, so case may be closed.
45. You are for?
Petitioner.
Sorry. Closed. Sorry.
Lordship, I beg to mention item number 8. Lordship, that may be allowed to.
MS M. Dev, learned counsel for the petitioner, submits that it has become, I think, infructuous. Submits that this matter has become infructuous. Accordingly, the petition stands closed being infructuous.
With the consent of the petitioner, my lord, with item number 59.
59.
Here I have received my instruction yesterday, my lord, also allow me 4 weeks time to file my affidavit. This is regarding allotment of a particular land to the association.
Okay, Mr. Bora, as per
For
a
whom?
learned counsel for the
GMC.
GMC, submits that he has received the instruction and then required 2 weeks time to file a
Related to 4 weeks, because
4 weeks. for
4
sure. Prayer stands allowed, list this matter after 4 weeks.
Lordship, I,
Mr. Bora, there is a hearing matter.
yes, it should be handled in the order list.
Huh?
It should have been lodged in
Oh,
the
in
directed
the
order.
order.
It has come again on hearing.
Is there, Lordship?
No. It's correct.
Huh. So
So, lordship,
basic issue is this. two parties of the same locality are fighting over use of a drain.
But overuse of it, there is a 2%, the parallel drain are being constructed, my lord.
Ah.
And one party has, one side has given all the land, their drain is there. Other side, there are some obstruction, they are not giving their land.
Ah.
And they want that particular drain to be joined this, so that their land are not been taken by the authority.
Have you filed affidavit?
I have filed affidavit, but GMC is not the authority who has given, that authority has, this is from MP-led fund.
Hmm.
And GMC is
No,
not
that
the-
is fine. Suppose, what will be the stand of the GMC? Suppose their basic claim is that, see, we don't have any place to, now there is no question of MPLAD using this fund. That is gone.
That is gone.
That is gone. Now, only thing is that, is there any real difficulty of these people?
Real,
If there are difficulties, anything is proposed by GMC, that is what we want to
that
know.
fund has not come to GMC, that work is not.
No, no,
done to the
suppose,
GMC.
forget about that fund. So is it your case that until and unless MPLAD fund is there, GMC will not construct that drain?
GMC,
Suppose a drain is required.
drain is,
If drain is required, will it be a case of GMC that MPLAD fund has gone? So therefore, let these people remain as it is. We don't have any response.
drain is required. Other side also requires the drain, but other side, some people are obstructing, they are not giving.
So
that
suppose
particular-
you can, is there a possibility that, okay, we'll construct a drains provided they give us the land?
Then that spot inspection has to be done by
So
the.
therefore, keep, that's why we ask you to have, the basic cause of action is gone. We
Okay.
can dismiss this repetition on that
Yes.
count only. But the grievance raised is that, see, our waters are not being allowed to go carry through a drain.
And-
And we don't have a drain.
These are self-made difficulties for that person on the other side.
Okay, you have a stand. If necessary, we'll give a spot verification, give a
Not-
report,
not-
then we'll dismiss it.
Not-
If it is for them, the drain was not done,
That are not.
then we cannot
In
help
fact, my
them.
lord, I have talked to the respondent side, they have made a good diagram, my lord.
Ah.
Those person petitioners who are obstructing. They- and
Okay,
after the-
okay, we'll see what will happen
Lot.
today, if it reaches.
Sorry.
That's why we asked to list
It
this.
should have come in the order list, my lord.
That's
That
why we
is-
have this directed to be in the order.
Still it is in the hearing list.
Okay.
Lordship, I beg to mention item number 7. Is the matter be adjourned for open bid?
Wait. 2016 matter. Yes,
I mean, this case.
anything survives. It has given to Connock. Isn't it?
Even otherwise, Milo, the cases still not maintainable.
Oh, forget about the maintainability. All people are technicalities in the report.
That is one aspect.
So
Otherwise,
that is aspect we can take later on. Issue is, you have taken possession of the vehicle, that was salvaged. That has been sold to some third party.
third party.
Now, what will you decide?
On the basis of which, Milo,
What will you decide?
even the contempt was closed.
Forget about the maintainability.
No, Milo, the contempt was closed on that ground. There was a contempt.
That we understand. Maintainability of writ courts do not say. We are in a writ court.
The Lord-
We are slowly forgetting that.
No,
And
but-
we are recalling ourselves that we are in the writ court.
No, but problem is.
Don't
it's a
say
private bank.
this
It's a private
maintainability.
bank. That is what.
Oh, private bank. Is it no writ is maintainable against
No.
private parties?
No, but
Not maintainable.
not on their space.
When you are doing a public function,
No,
is
Milo,
it not maintainable? Don't say all this
the
before
public
writ
function
court.
it is not a case of public function. Milo.
That will look into.
Lordship.
If we do atrocities over the citizen, will you sleep over?
No, the case is
Don't
different, Milo.
expect that. Don't
The
expect
case is
that.
different. Lordship will hear it. Lordship will
We
hear
have
it.
also done
understand.
some homework.
Yes, then.
We have also done some homework. Yes, next case.
So Lordship is taking up. Milo.
Taking up.
Lordship, tomorrow.
No tomorrow. In the ventilation, we'll remove the ventilation today. Yes,
If IA was filed to withdraw the writ petition.
Okay.
Because the dispute regarding the parties are already resolved.
okay, it is submitted that the grievance raised in the petitioner, in the present writ petition has already been resolved. closed. Yes. Naam to detail.
Item 63, sub-item.
Yes, Botagor.
There's a caveat, Your Lord.
So both.
Caveat is there.
Hmm.
Now, Your Lordship, this matter, Your Lordship, relates to Your Lordship,
The form says the details of the bank account.
bank account, Your Lordship.
Okay.
And I, Your Lordship, has mentioned it, and they say that, Your Lordship,
Where is the clause? Where is your form? Show us the
Lordship,
page.
Lordship, I.
Details of bank, page 57.
Page 57.
Proof to be
Lordship,
submitted.
proof to be submitted, Your Lordship.
Now, what proof you have submitted?
Lordship, proof, Your Lordship will kindly see page 126, Your
Huh?
bank certificate, Your Lordship. will
One,
be
one?
dated 117, Your Lordship. This is to certify that Mr. Prasanto Gogoi, I have mentioned about two bank accounts, Your Lordship. Son of this so and so. So this Tinsukia is reputed customer with a good financial standing. We shall be able to provide so and so. Now, Your Lordship, this is, Your Lordship, in my humble submission, is the substantial compliance, Your Lordship. Once this particular bank has said, Your Lordship, that I have,
Okay, that is so far relating to PNB.
Lordship,
What about that
that, Your
SBI?
Lordship, there is a bank guarantee, Your Lordship. We have also submitted. Before that, Your Lordship will kindly see that initially they have accepted my technical bid, Your Lordship.
Where is that?
That Your Lordship will get it at Your Lordship. Technical bid, Your Lordship will kindly come to page 123, Your Lordship. No, 123. 110, Your Lordship. It is 10 में की math? And next are 3, Your Lordship. Dear user, your bid for the tender so and so has been accepted during technical evaluation by the duly constituted committee, Your Lordship.
Where page?
Bank, after bank certificate, Your Lordship, next page, Your Lordship. 118, Your Lordship.
118.
Then, Your Lordship, the minutes, Your Lordship. 118, Your Lordship, this is a message came to me, dear user,
This message 5:19 PM on 15 February.
Lordship. They have accepted it, Your Lordship. And there is a minute also. Then, Your Lordship, will kindly come to page 122. That is also, Your Lordship. Then, Your Lordship, finally, Your Lordship, 124. This is the minute, Your Lordship, which I have put to challenge, Your Lordship.
Minutes is at page 24.
24.
What about this minutes? 13 to 2024.
Lordship, in that minute, it was accepted.
Where is that?
Lordship. Your Lordship, that Your Lordship, 119. Your Lordship.
119 page, the location?
Annex 4, Your Lordship.
Location?
Location, Your Lordship, Tinsukia,
Page 120.
120, Your Lordship. Galapuk, Your Lordship.
Pengri.
Not Pengri, Your Lordship. This is Pengri, Your Lordship.
PSK 6.
Yes. Prasanto Gogoi, Your Lordship. Considered for financial bid. Then page 120, Your Lordship will get the 124. It starts from 124, Your Lordship. Your Lordship will kindly come to 124, Your Lordship. At the very outset,
Who is representing excise?
I am applicant.
What was the occasion to
Yes,
re-scrutiny?
there several complaints were raised because lots of shops were tendered at the same time.
bank guarantee.
What is the present status?
Letter of award has been issued.
Letter of acceptance has been,
Hard-
license
yes,
has not been issued.
caveat.
Your Lordship.
Already deposited Chalan.
Well, stalling for the time being. We'll see, we'll want to see the record.
Just what has, I'll just place what has happened, why,
You bring on record, we are taking next week. Till then, no opening.
no, it has already been opened.
Open, what open? Shop is open.
The shop is not,
Not open.
bids have been opened.
He beats open, he has deposited. We are concerned about him also. We produce the record, we'll take up,
Very
next week we'll decide. it.
Lord, very well.
Heard Mr. Bhattakur, learned counsel for the petitioner. Also heard Mr. KP Pathak, learned standing counsel for the excise department, and Mr. Deka, who's the, Mr. N. Deka, appears on behalf of respondent number 5 on KVA. KVA stands research. Full stop. The present application is filed. Application is filed. Assailing assailing the decision of the bid committee dated 22/2/2024, whereby the bid of the petitioner submitted pursuant to a notice pursuant to notice inviting e-bids for issuance of fresh/new IMFL of shop license at location, what is called?
Pengri, Your Lordship.
No, there is a some
TSK, Your Lordship.
TSK 6, TSK, capital TSK 6. Full stop. It is the case of the petitioner that initially the bid, after scrutiny, technical bid of the petitioner was accepted. However, thereafter, a re-scrutiny was done by the technical committee and the bid of the petitioner has been rejected on the ground that petitioner has failed to give any proof against his bank account. Full stop. Mr. Bhattakur submits that such condition has substantially been complied with by the petitioner, and not only that, initially the same committee evaluated the bid and accepted the technical bid of the petitioner to be viable. Full stop. This matter needs further consideration. Mr. Pathak, learned counsel, submits that he will be able to produce the record of the bid evaluation committee. When?
Wednesday, Lord.
Next Wednesday?
Lord.
Next Thursday?
Very good.
Thursday.
Okay, Thursday? Next Thursday? Wednesday? Okay, next Wednesday. That is the give date, so. Committee, will you file an affidavit or you on the record only?
Perhaps, since Lordship is having the matter for motion,
Motion,
I'll produce the records and then
we'll see.
Lord.
Produce the record and for such and such date. Full stop. This court is also of the view that for proper appreciation and to see the reason for re-scrutiny of the earlier, to re-evaluate the earlier decision, the records is required to be perused. Full stop. The learned counsel for the caveator has submitted that pursuant to his selection for the site in question, he has already deposited the required amount of money before the treasury. Only formality is to start the shop in question. Full stop. Considering the matter in entirety and considering and to balance the interest of the parties, let the record be produced on Wednesday next, that is date so and so, and matter further consideration will be taken on such date. Till then, status quo as on today, as regards opening of the shop in question at TSK 6 shall be maintained by the parties.
Deeply obliged.
Item 39. Here.
Sorry, my lord. No, up to date case, there is not received, my lord.
Up to that case, there is enough.
On 5th of April, my lord.
5th of April.
Publishment.
For orders. Item 40.
None appears for the petitioner on call. None did represent the petitioner on 12/9/2022. Accordingly, this petition stands dismissed for non-prosecution. I see. Both sides, I see. Not.
Item 71.
Yes, Sarabhati.
Actually, my lord, I was instructed by my client that the matter has been settled outside the court. So they are going to make some submission that they would not pursue this matter. And now yesterday I got to know, my friend informed. So, my lord, I have taken instruction from my client. What is happening that there is some negotiation between EPIL and myself. So I don't want to disturb that. It may be another 2 sitting that will be sorted out. If I get money, then only they will get their share. So if it is taken up after 2 weeks or so, that is the instruction of my client, that with EPIL, there's some negotiation is on.
I'm for
Regarding
number 2 and
disbursement
5. We have some negotiation going on with respondent number 4.
Now suppose negotiation is satisfied, who will pay interest to this man?
No.
It is between me and
No, understand, why don't you resolve all these issues? It is pending since
it is,
2014.
my client said, my lord, it is resolved outside the court. They have entered into some agreement. Now, my lord, I don't-
That is why, my lord, our client has no objection because they have given the certification. And that your lordship will get as state that interim application IA. That has.
So what to do today, Mr. When will you pay the money to Chakraborty's client?
Settlement agreement going on.
So that is going on for last 7 years.
Give the instruction next week, specific instruction when we can dispose of this writ petition with a direction to pay, or we can make a statement, he can make a statement that it has become infructuous. Either of the one.
Lordship, the settlement agreement is going on between respondent number 4 and respondent.
So give us a proposed date by which time you can come back to the court and say that this resettlement is over. Yes.
If your lordship just have
IA.
IA at page 9, it is respondent number 4 certificate because that is the precondition to get.
IA number?
IA number, my lord, 1695 of 20.
1695.
Page 9, my lord. This is the certification given by respondent 4.
Okay.
This is the
IA
certification about
write down your
quantity amounting to 90 lakh. As per the agreement, it is so hence an amount of 90 lakh it's standing in favor of Northeast Engineering and.
This is
Industry.
third running bill or fourth running bill?
Third, this certificate will be treated as a valid certification.
Third running bill.
Third. Under clause 11, more particularly 11(3) of the agreement dated 8/10/20, Northeast Engineering Associates may move the nodal agency Engineering Projects India Limited project for release and realization of the aforesaid amount. So this was given in 19, and we have been trying to get that, and if your lordship.
Just listen, Mr.
Yes.
Goswami.
Yes.
Write down the order dated 6/6/2014.
Yes.
Repeat 6/6/2014 up to paragraph first, second. Second, third, first, second, third, fourth, fifth paragraph only. Okay. This matter was thus pending since the year 2014. In the meantime, the present IA is filed. Present IA is filed to contend that the certification so far relating to the third running bill has also been issued by, it is
Respondent 4. my lord.
respondent number 4 NEFFS. NEFFS.
Yes.
NEFFS.
India Private Limited.
NEFFS.
Respondent 4.
Within bracket, annexer B. Annexer B. Thus, it is clear that in furtherance of issuance of such certification, the petitioner is entitled for the payment against third running bill from the respondent number
EPIL
EPIL respondent number 2. Full stop.
2 and 5.
2 and 5. The respondent number, the learned counsel for the respondent number 2 and 5 submits that a settlement a discussion for settlement is going on between the EPIL and NEFFS, and moment such settlement is over, the payment will be made to the respondent number to the petitioner. Full stop. Mr. Goswami submits that the payment of due to the petitioner is not dependent upon any negotiation or dispute between NEFFS and EPIL in terms of the contract. What was required is the certification issued by the NEFFS, which has already been done in the case. Full stop. At this stage, both the learned counsel for the both the learned counsel representing EPIL and NEFFS prays that they may be granted some more time to obtain instruction in this regard and to apprise this court by what time the due of running bill number 3 to the petitioner.
That is only the amount.
Amount.
Certification is 90 lakhs,
Amount
so
amount under certification for the third running bill can be
amounting to 90 lakhs.
amounting to 90 lakhs can be paid to the petitioner. Accordingly, the prayer is allowed. List this matter on
After Bihu holiday.
give a consensus that ask Mr. Goswami also.
20. I am in a little uncertain situation. I am going for my some health issues
Okay.
tomorrow. I may have to undergo some.
Okay. Okay.
So one case I have fixed on 25th of April.
Okay.
So it
Okay.
can be there on 25th.
Okay.
or whatever.
25th of April.
let it be kept as part of before.
You have already, almost you have directed, anybody's
Yeah,
court, it
and
will come.
otherwise again it will go around.
Too many parts, it will come before this court, no problem on it.
It becomes.
Yes, yes,
Item 41 and 42.
You click.
এই annex আর কোন চাব the certificate is quoted here in below করে quote করে দিম
41 and 42 for orders.
Lordship may not take up this matter today. Mr. Borpujari was leading the case and he is not well today. Could not come to court.
he is not well for this case.
No, no, he has
Or
not come to
otherwise.
the court.
What is the issue here?
Regarding my lord's land completion,
Why this matter is listed in the order column? Okay, to decide. It is submitted that Mr. Borpujari, Learned Standing Council for Revenue is indisposed today. Accordingly, a prayer for adjournment on his behalf is made. Prayer is allowed. List on
first week of April.
when tell us first week of third of April.
Of like,
My appearance may be soon. I am for NHID.
Okay, Talukdar for
NHID.
RK Talukdar for NHIDC.
Both cases, ma'am.
Both cases.
Item 43.
Lordship, in this case, sometime is required, Lordship, to place the matter before the subdivisional level advisory committee, Lordship. The
What is
matter,
the issue here?
matter relating to, Lordship, the allotment of land to the Guwahati Jilla Tholua Hak Pasuli, Lordship, for their permanent market.
MSD, Mrs. D. Bormon Learned, additional senior government advocate, seeks for harder time to obtain up-to-date instruction. Now, nobody is appearing redress.
Yes, Lordship. So, in law, since long time, Lordship, petitioner is absent, Lordship, but as per direction of the Honorable Court, Lordship, I
Two weeks, 3 weeks,
4 weeks, Lordship,
4 weeks.
outline, Lordship.
Item 44.
Speaker, Lordship, Lordship may kindly grant 2 weeks time to file impeachment petition, Lordship.
Huh?
Kindly grant 2 weeks time to
Hmm.
file impeachment petition.
Learned counsel for the petitioner prays for and is granted 2 weeks time to file impleadment petition. List accordingly.
Item 46.
None appears for the petitioner on call.
Lordship, I am appearing. Lordship, he has got the.
I think so. Mr. Mr. P. Nayak appearing for the respondent submits that the refund directed to have been made to the petitioner has already been made. It could be that as it may, as none appears, this contempt petition stands upon.
They have already received the fund. 46.
Received, but
Already.
nothing is there. Anything is so as we'll close it.
Yes, Lordship. I will.
Okay. Mr. Mr. RM does submit, also submits that they have received the amount on.
Oh, Muslim, sorry. No.
Then that's it.
Lordship, I am also receiving one WhatsApp, copy, Lordship.
Okay, accordingly.
Lordship, may not record them, let him come, Lordship, or on the next day, Lordship. will-
No, they're closing it. Dismiss for
Lordship.
default. Otherwise, he'll not come. But since
So
contempt
far as my information is
Uh,
concerned, he has already.
submits that none appears for the petitioner on call. However, Mr. P. Nayak, Learned Counsel submits that the suspension has already been filed. In view of the proceed, the contempt petition stands closed.
Obliged.
Item 47.
You are for?
FPTCL.
Respondent
number 2.
None appears for the petitioner on call. The petitioner has not taken steps in terms of steps upon respondent number 6 and 7 in terms of discourse order dated 29/2021. The subsequently, the Lawajima court under its the office note dated 5/3/2024. No, thereafter, the Lawajima court under its order dated 10/2/2023 also directed the petitioner to take steps within 10 days. Also directed to take steps. Thereafter, the petitioner was granted time for 10 days to take to comply with the Lawajima court's order on 10/2/2023. By the Lawajima court, and subsequently also when no steps was taken, the Lawajima court by its order dated 7/3/2023 has placed this matter before this court. The petitioner is granted 10 days further time to take steps upon the respondent number 6 and 7. Full stop. If no such steps is taken within the aforesaid period, the writ petition shall be treated as dismissed for want of steps without further reference to this court.
Item 48 and 49.
Please, Your Lordship.
Yes.
As per direction of this honorable court dated 22/11/2023,
Hmm.
that notice be issued in 2 newspapers, one English and one particular, having wide circulated in respect of.
Where is the affidavit?
So we have filed this affidavit, Lordship. As per
Upon respondent number,
8, 11 and 14.
notice served according to you.
Yes, Your Lordship. By way of paper copy.
Okay. In terms of this court's order dated. Order dated
Order dated, Lordship, 18/11/2023.
18/11/2023. The steps to substituted mode and through paper publication has been taken by the petitioner. Full stop. An affidavit has also been filed annexing the original newspaper. Peruse the same. And service in respect of respondent number. Aforesaid respondent numbers 8, 11, and 14 are accepted. Anybody appears?
Yes, sir.
Yes.
I'm appearing in WPC number 323 in respondent number 15.
No, not 15. Oh, I am saying about 8, 9, and 11.
No,
Okay. Accordingly, list this matter in the admission column after weeks.
Obliged.
May it please your lordship. Matter is become infectious, lordship.
Why?
Lordship, in item number 50, there is a repetition for quashing the notice dated, quashing the notice dated 7/3/2023. After that, they filed a contempt petition. Then, as he received the notice of this honorable court, that he immediately cancelled the notice dated 7/3.
Okay, give the repetition. Where is that? You have filed affidavit?
No, Lord.
Anything to say that yet? What do you say?
Yes, my lord, my senior is not well today. We want to take some time.
Why you want to take some time?
There are some legality involved in here. He cannot, the Qazi cannot do it itself. The court can give the direction to cancel it. There are a lot more legality involved.
What is the challenge in the repetition?
Challenging the notice issued by the Qazi respondent number 3, that dated 3/7/3.
Space. Page in the repetition.
Lordship, Annexure 5, Annexure 5.
Two petitions are there, my lord, 1114 and 1595.
1114, tell us. 1114. What is the challenge in a 1114?
That is, my lord, the page number 13, my lord, the notice that was issued by the Qazi regarding cancellation, divorce notice, my lord, that was issued. And divorce proceeding was instituted by the wife, my lord.
So this notice is withdrawn.
Yes, sir.
That notice has been withdrawn.
Now what remains?
Nothing.
Nothing remains.
As per instruction of my senior, he is.
No, see, forget about this. And then what is the next repetition?
My lord, next is the third one. Third notice was issued by the Qazi.
This is also filed by the same petitioner.
Same petitioner.
Where is that notice?
My lord, in
There was
Annexure 5.
there was an order passed by the court in 114 that they cannot further do anything. There was a stay proceeding. Then they again filed another application there. So that's why we filed that.
So it is at page 15. Kulatala. Page 15.
Take page 22 notice. Thank you, notice.
That is in repetition 1595.
And that is written in one side.
Now what to do? He has issued a Khula Talak notice. Court stayed this. Then he called, please come once again. You have already issued. Then both withdrawn.
Both withdrawn. Even I am respondent wife, my lord. I have filed an affidavit stating therein that I am ready to accept that the Qazi has no authority to issue the notice. So I may be allowed to, I may be given the liberty to approach the honorable court, appropriate court for filing divorce.
There is another restitution case is filed by my petitioner in a family court already.
That is not a subject matter here. Hard. Both the case hard, Mr. Both repetitions.
A
Hard,
Mena on
Mr.
behalf of F Khan.
A
Mena, MENA.
A Mena on behalf of F Khan, Mr.
SRA Nasir.
SRA Nasir, Learned Counsel for the
Respondent number 3 in WPC number 1959, and in contempt case, it's the sole respondent.
okay contempt will cast later. WPC
1959.
You are the husband, wife,
I am the Qazi.
Qazi.
Respondent number
and what,
I am
your,
respondent number 4 wife, my lord,
in
in both the writ petition.
both the writ petitions. Your name, please?
J. Hussain.
J. Hussain. Full stop. WPC 1959 was preferred by the petitioner assailing a notice dated 7/3/2023 issued by the respondent number 4 on the
Respondent number 3.
on the respondent number 3 on the request of respondent number 4. Page 20.
There are
Uh,
3 notices.
Notice dated 7/3/2023. The grievance of the petitioner, the grievance of the petitioner that is that on the behest of the respondent number 3, respondent number 4, the respondent number 3 is issuing notice to the petitioner to appear before the respondent number 3, who is a Qazi, for the purpose of a khula talaq. It is the case of the petitioner that the respondent number 3 is having no sanction and authority under law to issue such notice. This court, having prima facie satisfaction, stayed such notice by its order dated
1/3/2023.
By order dated 5/4/2023. Isn't it?
1/3/2023 in repetition.
In repetition 1/111.
Hmm?
1/111.
1953 will be for previous application.
Last
application 1959.
Earlier writ petition is
1114.
1114. By an order dated
By an order dated 1/3/2023.
1/3/2023. 1/3/2023. Even after such interim order, yet and other notices were issued by the respondent number 3, asking the petitioner to appear before the respondent number 3 for the purpose of determination of khula talaq. Such proceeding, such notice was again challenged in WPC 1959/2023, and the contempt petition being contempt case 234/2023 was filed against the respondent number 3. While the matter is taken up today, the respondent number 3, the learned counsel for the respondent number 3 submits that the notices has been withdrawn
And cancel.
and cancelled and it is further submitted by the learned counsel for the respondent number 3 that the respondent number 3 admits that he will have no jurisdiction to exercise his power to grant a khula talaq by issuing the notice as has been done. Accordingly, it is the case of the respondent number 3 that notice, the proceeding for khula talaq has been closed. The learned counsel for the respondent number 4 wife also submits that she has also decided to take recourse by filing divorce proceeding before the competent court and not agitating her grievance before the Qazi. that being the position, nothing survives to be adjudicated in this present writ petitions. Accordingly, the present writ petition stands closed. Contempt likhib, in view of order passed in the writ petition, the contempt petition stands closed. Writ petition likhib further, disclosure shall not bar the petitioner to approach once again this course if the respondent number 4 or respondent number 3 initiates fresh proceeding of khula talak. Full stop. We have given you a liberty before the Haji. Closed.
Highly obliged.
May I please the property?
Hmm.
Order is supplied.
Hmm?
The order is
Complied with, disposed of. RM Das for
Respond number 2 and 3.
2 and 3.
Method for 1 and 4.
Yes,
Like-
disposed. Next.
May I please your lordship, my lord, say prayer, my lord, matter may be taken up at 2, my.
Matter may be taken up at 2.
Yes.
Why?
My lord, the leading counsel, Mr. SJ, he is on different court, my lord, he will be here at 2.
At 2 will not say at 2. Let us see
Yes, my lord, keep your blessing.
for a time being.
Number. Lordship, this IA has been filed by me for seeking release of my vehicle, lordship. What happened, lordship, in this case? The IOC called for an tender, lordship, for transportation of bulk petroleum product.
Hmm.
And we are the successful tenderer. The unsuccessful one filed a petition making certain allegation our vehicle was wrongly registered and all. There is a case, police case was also registered, lordship. Police has filed final report saying as no case has been found out. That I have been annexed to my IA, lordship.
Hmm.
So in view of that, lordship, this court in the interim also allowed our other vehicle to run.
Hmm.
And now the petitioner also lost interest. It is not appearing.
Last
Last
occasion
two occasions.
Now,
Lordship.
what do you want?
My vehicle has been lying before the CID, lordship. That I have surrendered voluntarily on the direction of this court. That lordship seizure will find.
Where is the order?
Order lordship will find in the writ petition. Order dated 5/12/2022.
Order dated?
5/12/2022. The last lordship,
দুইটা একেলগে ল'ব হা আয়ে আৰু এই দুইটা একেলগে ল'ব 5/12/2022
the last penultimate lordship is starting from we have also requested BJ Talu. Lordship will find that lordship. Order dated 5/12/2022.
and where is your final report?
Final report is lordship annexure 4 page 13 of the IA.
Is 13.
13. It's 13 to 17. 13 is the type copy and the certified copy lordship will find at page 16.
Okay. Now, where is the interim order? First interim order.
There is no such interim. On the basis of this 5/12/22, I voluntarily went and surrendered my vehicles. That will find in reflected in the lordship seizure list itself, page 10. Serial number 2, seized as produced by Sri Amarnath Prasad. My driver went and surrendered. Lordship.
Okay. None appears for the petitioner on court.
On last occasion also he was not appeared.
My vehicle is AS09 AC 9075.
Just a minute, just a minute. We'll put a heavy cost upon this person to be recovered as a areas of revenue. The present repeat none appears for the petitioner on call. See, for him, there was an CID inquiry, stay,
Yes, my lord.
wastage of judicial time, and he is not appearing.
And last occasion also, lots of mechanic.
None appears for the petitioner on call. None does represent the petitioner when the matter was called on such and such date. Okay. The present writ petition is filed, praying for setting aside and quashing letters of acceptance dated 31/08/2022 issued by Chief General Manager within bracket contract cell bracket close ERO capital comma IOC within bracket MD in favor of respondent number 4 to 21 pursuant to an NIT dated 26 to 2022 2022 for allotment of 70 numbers of tank trucks for road transportation of bulk petroleum products at Digboi Terminal. The further challenge is letter of acceptance issued in favor. Further prayer was to issue a mandamus. Further prayer was to issue a direction to the respondent authorities to issue letter of acceptance in favor of the petitioner. Full stop. The petitioner, during the course of hearing, alleged certain serious illegalities. So far, the same relates to supply of vehicle in terms of the tender by the respondent number. You are respondent number?
I'm respondent number 6.
Respondent number 6. In the aforesaid backdrop, this court, under its order dated 14/3/2023 and
5/12/2020.
Huh?
5/12/2022.
5/12/2022, ask the CID to verify the alleged anomalies that alleged to have been committed by the respondent number 6.
Not against me also, respondent number 4.
Successful
tenderer.
against the successful tenderers. Accordingly, by this court under its order dated directed to
5/12/2022.
5/12/2022. In terms of such order, the respondent number 6 has handed over the possession of a vehicle bearing registration number
AS09 AC
AS
09
09
AC
AC
9075.
9075 before the CID. The CID Assam has also registered a case being
Lordship, this was on the final report is on the basis of another FIR was also filed. Digboi PS case
Full
number
stop, full stop.
180.
In the aforesaid backdrop, an FIR was also filed being Digboi police case number 183 of 2022.
Lordship.
1/8/2022 under section 406, 468/471 IPC. Thus, the vehicle of the petitioner was under custody of the CID during the investigation. In the meantime, the CID has submitted a final form under section 173 of CRPC, closing the investigation and exonerating the petitioners.
Responded, applicant.
The respondent vehicle owners. Respondent vehicle owners. Full stop. In the aforesaid backdrop, the connected IA being so and so is filed for direction of release of such vehicle from the custody of the CID, in as much as such custody was taken subsequent to order within bracket supra of this court. Full stop. As none appears for the petitioner on call, this writ petition stands dismissed for non-prosecution. As the writ petition stands dismissed and the CID has already granted, already filed final report in the case, comma, in the considered opinion of this court, there is no requirement for purpose of determination of the present litigation to keep the custody of the vehicle in question under CID. Full stop. Accordingly, it is clarified that the vehicle under custody of the CID may be released even if the said vehicle is not otherwise required by the CID. That's all, because we will not go till.
Only one
Another vehicle matter.
One
Full stop.
observation, Lordship. My peso license, that is petroleum and explosives, that have kept in withheld because of this order. So that authority may also responded number, Lordship.
It is also submitted that for the pendency of this writ petition, the license to operate
The peso license and also my motor vehicle license, the registration, Lordship.
the registration license as well as PESO license of the petitioner has been not kept in hold. Full stop. It is made clarified that there is no bar for renewal or continuation of such license for the pendency or by virtue of this order, for virtue of this order, and the authorities shall be at liberty to proceed in accordance with law. Okay.
Lordship.
This court has observed that the petitioner has assailed the process of NIT as discussed herein above and remain absent on last two occasions. And in the meantime, not only valuable judicial time is wasted, this court had to issue direction for CID inquiry also. In the process, valuable judicial time has been wasted by the petitioner. Accordingly, in the considered opinion of this court, this writ petition, the petitioner should be imposed with a cost of rupees 50,000 to be paid before the cost of 50,000. Where is his resident? He is resident of
Sitsagar.
the Deputy Commissioner.
Page 4, Lordship.
Page 4.
4 of the writ petition.
The Deputy Commissioner shall issue notice to the such cost should be deposited before the Guwahati High Court Legal Services Committee. Full stop. The registry shall issue a notice to the petitioner in the address declared in the writ petition asking such deposit of money. Such payment be deposited within a period of 4 weeks from receipt of such notice from the registry.
This order will be in the for 55 only. 56 is
Okay.
another successful tenderer. He has not assailed the need.
Okay, 55, that
Only
is
55.
6839.
Got it.
6839.
Lordship.
Now, what is the other matter?
Very other vehicle Lordship, Lordship, my lord has dismissed this petition. Lordship may kindly object that also. We have suspended another car's permit in regarding this case.
In item 55, Lordship, I was here for respondent number 22. 55, 56 and
This is whose vehicle?
It's some private respondent member. He's not.
Okay, we'll segregate this. We'll hear it some other day.
Sir.
When?
Next to that, madam.
Okay. It is segregate, comma. As the connected writ petition has already been dismissed for non-prosecution, this matter be proceeded independently. Connected writ petition being WPC number 6839/2022 being dismissed for has been dismissed, comma, this writ petition shall proceed independently. List this matter after tweaks.
We have suspended till disposal of this matter. Since my lord has dismissed this, there's no effect, this order, my lord.
Will not say anything.
My lord. Okay, my lord.
What are these IAs? IAs in IAs dispose of.
Dispose.
IA in this case is only this. IA 59 in which case? That is different. IA 59 is 6839. Your writ petition is 6839.
6839.
What is this IAC IA? By MK Chaudhary.
By oil, ISO.
Passing appropriate order in connection WBC. What is this? All IS stands this. It will GK IS dispose of. property.
Lordship, I think this is nothing.
survived it after dismissal.
All IS in WPC 6839.
Lordship, I'm appearing for number
Okay,
23.
MD Boraha, 2N,
Transport department, 23 months.
Transport Department,
I'm for 22.
SS Roy,
22. respondent
22.
number 20.
I'm
and you are?
For I-
ISL Bora. Okay,
My lord, as per office note, my lord, I have to take steps upon reference number 13.
Hmm.
It is in the correct assessment. Other
okay, in view of office note dated 11/3/2024, the petitioner is permitted to take fresh steps in proper address, steps upon respondent number 30 in proper address. Mr. Sharma, RP Sharma, Lane Senior Counsel is present on behalf of
yes, file my lord, implement.
7A.
Mistake. It's not
implemented.
not implemented. It's
Will implement him.
in the it is for listed for today, my lord. File on objection, my lord.
Where is the IA? Why you want to object it?
Because my lord, we
What is the issue? Tell us.
issue, my lord, with the government has appointed some members in the board, my lord.
Board of what?
Board for SC/ST welfare board, my lord.
Hmm.
And as per the constitution amendment schedule, my lord, those other than Bormon are not ST in respect of Borakali. Only the Bormon
Who are
community.
you?
I'm the Bormon community people.
Okay, you
What?
you have been appointed
No,
board.
no.
No.
Some in the private.
Okay,
respondent-
non-Bormons were appointed.
Appointed.
In place of Bormon, non-Bormons or something is appointed.
Yes.
So you are agreed.
Yes.
Now, who is he?
They are the community belonging to non-Bormon Khasi community,
No,
Naga community.
So they say that we have also right.
They
Isn't
have,
it?
actually, they have no right.
No, they have right or no right. We cannot decide in an implement petition.
Yes.
They claims to have a right. So should not we hear them?
As your lordship, my objection.
No, you have said you have, why should we record your objection? You raise your objection. What objection should you raise?
Objections, my lord,
Don't argue on merit. We cannot decide anything of merit in the implement. Okay? Hard, so RP Sharma, learned IA. 6178. RP Sharma, learned senior counsel.
570, I.
570, yes, IA 570. RP Sharma, learned senior counsel, assisted by
$.
G.
$.
D. Dole. D. Dole. And Mr. R. Dhar for the
For 1 and 2.
for respondent number 1 and 2. The present application is filed to implead as intervener / respondent number 14. Mr. Sharma, if you are an intervener, you don't have any right to file affidavit. If
No,
you
no.
are if you are a respondent,
No,
then you
I am in the main case. Actually, my name was wrongly given here. In this case, actually, Dole is leading it. Dole is the main leader. But I was mismatched, my lord. With the
so for whom?
I am for the
Only one respondent, 14.
14.
Okay.
For him.
Application respondent number 14 in connected writ petition being WPC 178 of 2023. The
Let him be registered by the private student.
okay. The statement made in the IA. I have perused the statement made in the IA. As the determination is the connection writ petition, the determination in the connected writ petition might affect the right of the petitioner in the long run in view of the effort and not objected to by the learned counsel for the petitioner. The present IA stands allowed registry to correct that so and so. IA stands disposed of. Main case likhibo. In view of office note dated 11/3/2024, the learned counsel for the petitioner prays for and is granted 10 days time to take steps upon respondent number 13 in proper address. So far relating to the service upon the other respondents, await the service report. Yes, list after 2 weeks. Order yes. Yes.
Well, as per office code 11.3, service is not complete, neither petty nor contract.
Await service report. In view of office note dated 11/3/2024, await service report and list after 4 weeks.
Let may I pay for logic to place.
They will do it. Very recent steps. That's why. Automatically they will give to the item.
For the restoration of the contempt petition 700 of 22.
Where is the order?
Page number 23.
Huh?
Page number 23. And except 2.
This is not restoration. This has been decided.
Well, in the other case, in this case, the counsel of the applicant made inadvertently made a wrong submission by placing the order dated
Give the contempt petition.
11/10/2023. That is page number. Both cases is not connected.
Petitioner submitted.
Yes, sir. This is the wrong.
Now, how can you say that you can restore it?
Well, that order is different method. So
Where is that order?
that is page number 9 method
9 of what?
of this IMA.
Hmm?
IMA. By placing this order, the advocate of the submitted that
Where page number?
page number 9 method 11/10/2023 passed review petition number
Okay, we'll take it up some other day. List this matter on next Tuesday.
Or my lord, I may be allowed to file a price in contempt petition.
Huh?
I may be allowed to file a
We'll see. We'll have to give a reason. Na? You have said it has impact on what review. We'll have to apply our mind, not at this. Yes.
public.
See,
Yes, sorry.
isn't it? Vehicle has been possessed by a private company. Okay? Then that has been transferred to Konok. Who is representing Konok?
Lordship, he is not before the court.
You have not made him because on the affidavit Konok has, this is pending till 2016.
Because Lordship, the vehicle is lying in the police station. So-
What is your right? You file a suit, declaratory suit.
And Lordship, before setting off the vehicle, we are not being.
You are
given
not a
opportunity.
registered owner
Lordship, we have annexed our registration certificate.
because that registration has been transferred.
Lordship, let my senior come and argue this matter. Lordship, kindly accommodate. Mr. Taylor. He is out of station. In the previous occasion, we have never taken back. So kindly. Adjourn, sir.
Now tell us how a writ petition is maintainable against IndusInd Bank.
Lordship, as I have said, they have not intimidated us before selling. on the
Understand,
vehicle.
understand everything. Now a writ can be issued against whom?
Lordship, the only request we want is that we may be
Give
allowed.
me one very small thing, but we must have a power to give you. Okay,
We are ready
when
to
will
pay
be
the
your
installment. Lordship.
this is not a panchayat. Yes, huh?
Mr. R.D. case. You kindly adjourn for today, let, in conducting counsel come and argue.
Call family wants to keep the ventilation for 48 hours or 72 hours.
It's just for a day, but.
So 24 hours.
He has been to Lucknow.
Okay,
Only difficult.
they submitted that the learned counsel for the petitioner, Mr. G. Chaudhary, is indisposed today. Accordingly, prayer for adjournment is made. Prayer stands allowed, release this matter after 2 weeks.
That's obliged.
Item 9.
May I please, Lord?
Hmm.
Matter pertains to my lord, payment of additional executive, my lord.
Hmm.
Earlier, petitioner was paid, my lord, 1 lakh, my lord, and subsequent, my lord, notification, they are entertained another 2 lakh.
Yes, Gogoi, what you say?
They have filed affidavit, my lord. There is not admitted.
So they will pay you. Now why our direction is required? So it has become infructuous.
Yet not paid, my lord.
Yes, Gogoi, what you say?
In the office file, the draft affidavit, whether affidavit is in the record or not.
Record, it is in the record, Lord.
Affidavit is a record.
Second file, second file.
Here, who died?
My lord, I have given the chart, my lord.
Where is that?
Page 6.
Page?
6.
This is a writ petition pertaining to all these persons. How will they decide in one writ petition?
Earlier also they, my lord, sanctioned the amount in common order. That is, my lord. Page 19, my lord.
Is of one family.
No. Okay. Page 19, my lord. Earlier they paid, my lord.
You dictate an order. I'll sign it.
Then I may be allowed to do with liberty to.
You dictate an order, I'll sign it. And thereafter, don't allege that it cannot be complied with.
I may be allowed to do with liberty.
How will you record the facts? Who died? Where died? Who is claimant. In the earlier order, yes, we have seen. We have recorded the facts. How will you record here?
It's only.
Learned counsel for the petitioner submits that due to defect in the petition of arraying or of filing joint petition, though their cause of actions, though there is no common cause of action, you want to withdraw this petition and file separated petitions. Prayer is allowed. Please.
Matter let relate
MLC, I pay for some accommodation, Lordship.
Circle officer filed affidavit.
Today morning, I have received one communication, Lordship. As per I so last order, unable to last order, we have to receive student instruction, Lordship. Lordship may,
But circle officers affidavit is categorical.
so Lordship may give 7 days time, they have paid, Lordship.
The present petition is filed by the petitioners with a grievance that though their patta land has been acquired for construction of railway lines from
Tetelia to Bornihar.
Tetelia to Bornihar.
Yes.
However, they have not been paid land acquisition compensation. The circle officer of the concerned revenue circle has filed an affidavit, and in the affidavit, a specific and detailed detailed statement has been made that the petitioners' land were acquired for the construction of the aforesaid railway line, except paragraph 24 of the petition. Which paragraph? Who is paragraph 24? Who is that? Paragraph 24 of the petition.
It's a actional land.
Except the land described in paragraph 24 of the petition, which according to the circle officer is a purely government land and same has been issued for the construction of the line. In the backdrop of aforesaid stand, Mr. K. Gogoi, learned counsel, submits that railways may be granted.
No, Lordship, circle officer seek whether that amount is there.
You are for?
I am here for Lordship circle officer.
That is the confusion. Sometimes you are for railway, sometimes you are for. Now what railway? Who is railway? Have you made railway
No,
party?
Lordship, railway- Not party.
Lordship,
Huh?
I made party by hand plot. As per court order.
What is the court's order?
This one number 4. I have served notice also.
Serve notice. Where is the order? Huh? Which order?
Nice.
This court, under its order dated 28/1/2019, on the verbal prayer of the learned counsel for the petitioner, the NF Railway, represented by the General Manager Maligaon, Guwahati 11, was arrayed as respondent number 4, and notice was issued to the said respondent. Notice was directed to be issued by registered post with AD to the respondent number 4. Office note dated 10/4/2019 also reflects that the one counsel entered appearance on behalf of respondent number 4 by filing wakalatnama. That being the position, respondent number 4 is duly represented. You cannot now
No, I cannot.
because there is a conflict
I
of
cannot.
who will. Respondent number 4 always.
Then Lordship, my brother will appear. I can.
You are in
No,
you are CGC.
No, no,
No, no. For the, I thought it was for the state.
Okay, I got to look for S. Borua. Mr. K. Gogoi accepts, Mr. Ko Gogoi is present representing the railways. Full stop. Even লিখার দরকার নেই করলো না একো দরকার নেই আগরখিনি হল this was the stand in view of such stand of the circle officer Mr. K. Gogoi, learned counsel representing the Agoto S. Bura boli dibo. Learned Mr. K. Gogoi, learned counsel for the railways, submits that he may be granted 2 weeks time to obtain instruction from his client and apprise this court, and if necessary, file affidavit in opposition. Okay, list this matter on after view. An affidavit has been filed with Sigol, Sidago, in view of the deficit, Kego, learned standing counsel.
Kindly fix that. Sorry. Obliged.
Okay, reflect the name of Kego.
Yeah, please, Your Lordship. Very recently, the private respondent number 4 has filed an affidavit in opposition. The petitioner wants to file an affidavit in reply, my lord. Kindly give me 2 weeks time, my lord.
Yes.
I am appearing on behalf of respondent formal affidavit has been filed. So, this is my lord.
You can buy a what was you can buy a vehicle. Huh?
Yes, ma'am.
And you don't have money to pay insurance. What are your other properties? Let us tell. Let us know.
Present, my lord. The respondent number 4 is a lady. She is working as cook, my lord.
What is her husband doing? What is her husband doing?
Now, she recently married. Her husband is a laborer.
Now, how from we'll have to give an investigation. From where have you bought a vehicle?
Yes. Vehicle already sold, my lord. After accident, the vehicle was.
We do not
due
know.
to her poverty, she could not make the payment for insurance. So
You can buy a vehicle.
Yes.
And could not pay insurance. And in the meantime, somebody expired. Have you filed any claim for that under the 2014? This policy is meant for people like this, not for everybody and anybody. Okay, learned
Your
counsel
lordship kindly see the order.
will not be kind to you. That is assured. Will not be kind to you. A learned counsel for the petitioner seeks some time to go through the reply affidavit filed by the respondent number 4 and to respond if so advised. Accordingly, matter stands adjourned and be listed after 3 weeks.
Please, dear lord. The petitioner is a policy holder under LIC mandate. His policy is said to have been assigned by some loan has been obtained by 2 banks. It is
By whom?
by somebody representing myself, fraudulent.
Hmm.
None of the documents tally, my handwriting, my signatures do not tally. I've taken up this matter with LIC as well as I have the police complaint also. Nothing has come out, and therefore I am before your lordship.
Hmm.
By the time I filed this writ petition, I wanted some advance, which was allowed.
That is no more.
Now it is gone. 22, the policy has matured. And he is now 68-year-old, suffering, and then even now, LIC has not made any effort to actually go into the
Have you lost any complaint?
Yes, ma'am. Police complaint is there.
Where is
And now
that?
most important is that, my lord, the original policy, our last occasion, lordship wanted to see the original policy. Original policy is with me. And now they're saying that they have assigned this policy. How the original be with me and they assign?
Yes, insurance.
Lordship, our specific stand is the original policy has not been produced before us.
How can you assign?
No, Lordship, our specific is that we have assigned and the policy has, loan has been given and loan has been.
Loan given to whom?
Given to the petitioner. Our case is the petitioner. And we have confirmed that the account is on the name of the petitioner. It was also not denied that the account is in the name of the petitioner. And the amount was also withdrawn. 13 lakh has been loan sanctioned. 13 lakhs payment has been done. The same, it was withdrawn. But
in whose account?
It was
Somebody representing Ashutosh Chaudhary.
our,
I was in Bangalore. I was not even aware how this has been done.
Which one is this bank?
Two banks, my lord, Canara Bank and Central Bank.
Who is representing them?
Mr. Sharma was representing Canara Bank. They have filed one affidavit also.
What is just then?
They're saying, no, we have verified the documents. Verified the documents, I have filed my rejoinder.
They transferred to whose account? Cash withdrawal.
Cash, they transferred the amount to the account open. Defrauding my some PAN card and electricity bill. In electricity bill, my name is, my lord, my name is there. The other
Now, who is investigating?
Nobody is investigating.
Where is the FIR?
FIR is there. Well, what they did, my lord, they came, their officers twice, they visited my house and they are asking me now, they are after me to hand over this original. Why should I hand over my lord now? I don't trust them only.
Who want to hand over it?
LIC. Now they want these original policies, I should hand over to them.
we visited the home. Our specific is we have.
Okay, we'll ask you to hand over in our presence, but don't use for anything.
My lord, let them now, my lord, let them give my money back. That's it, my lord. They have not
Let them
made
verify.
any inquiry. My lord, 2018, I have 19, I have filed. 2024, they have not made any inquiry to find.
They
out
have
this fraud
sanctioned lane against this policy
against this
in favor of whom?
Against Ashutosh Chaudhary and we have made the payment and we have taken the annexure B in my WS in my reply, lordship. There is a bank letter. The bank has stated that it is in the name of the Ashutosh Chaudhary. This the account where we have transferred the amount. It is in the name of the Ashutosh Chaudhary. That is the petitioner. Annexure B, page 12, lordship. And annexure A is the first page of the bank account, lordship.
Have you made the state government a party?
No.
Then how can I ask them to do investigation? Finally, we need to know that this is it is not you who has the beneficiary.
That
How will you determine in a writ proceeding?
LIC can very well determine that.
They have said, no, you have transferred it to your account.
My lord,
Whether your case is that, no, I have not sought a loan. How that will be verified?
neither my signature, PAN card also, some photograph.
Who will decide that this is not your signature? It is a matter of criminal investigation.
FIR is.
Even if we want to monitor the criminal investigation, they are not the party before us. The prayer made we cannot allow. Is it not? LIC has taken a stand, which is a disputed fact. If there is some investigation, taking note you are a senior citizen, that would have been a different thing. We have done in some other cases. Now, which story will you believe? We cannot have a roving and fishing inquiry. We can at best ask on the basis of your FIR, what happened to that investigation? Any knowledge?
No, nothing has been done. Nothing has.
But you have no grievance.
I have grievance, my lord.
But have you have
Where
not?
do I go, my lord? That is the whole trouble.
You know where to go because you are standing in front of this court. You know
My lord,
where to go.
I have implemented these two banks and the LIC
But
also.
you have come to this court which we cannot determine. What we can do, you have not seeking, and in absence of prayer, we cannot do that.
But then I think that is when I'll immediately switch off that.
MSP Chakraborty Learned Council for the, and you are also in difficult. How can you grant a loan without deposit of title deed, and you say that it is a equitable,
Assignment by law.
it is an equitable mortgage?
Under the.
Tell us, can a equitable mortgage be there without deposit of title deed?
No, our case is the title deed has been deposited.
Where is that? That is it her.
That is
What is
that is
this
it.
then?
That is that's why
Title
Lordship,
deed is
we have,
her.
that is Lordship, we have
Now she can even take a loan if
Yes,
she
that
can
is-
defraud any bank showing
Lordship,
that
Lordship,
give me a loan.
That's fine. Let the inquiry be done. Lordship, let him.
Who will
make
do
the-
inquiry?
Lordship, let him make the
You
step.
don't have any responsibility. That somebody,
I have a responsibility.
somebody has played fraud upon you. Maybe your officer is
We
involved.
have also lodged an FIR, Lordship.
What happened to that?
To the
MSP Chakraborty, we want to help you, but in this way we cannot help you. P. Chakraborty seeks for an adjournment to complete her instruction. Prayer is allowed, least after 3 weeks.
Can it be my lord 1 week? I'll do it 1 week. I mean,
You are not in hurry.
I tried my best, my lord.
No, you are going on a wrong way. You will not get anything there. The way you are going, we call it Kaso Koni. You are searching in a hill. You'll have to go to the sea
I'll file my,
and sense.
file my.
You do
within
after
1
3
week,
weeks.
my lord.
After 3 weeks.
Yes, got it.
Cancellation of patta.
Yes,
What is the procedure to cancel patta?
26 is there. Before that, Lordship, may I please read this paragraph, page 57, Lordship,
Page 57.
and extend. That is the impugn order. May I read?
Hmm.
Lordship, can please take note of the date, 20th September 2018. This is the order part. Pertinent to Malabari Unnayan Secretary, Malabari Unnayan Samiti are present. President of so-and-so committee read the relevant land record. Government in Revenue Department has requested to take necessary action for cancellation of patta of land measuring 8 bighas covered by Dag number 378 of the village Malabari under the Kamalpur Revenue Circle, which has given settlement of land to so-and-so committee as per the rule of the Assam Land Revenue Manual. In this regard, read the relevant land record, land policy 1989 and the government circular regarding the requirement of the approval of the state cabinet. Lordship, that is the ground, Lordship. Lordship, I'll read slowly. A case has been taken up, RR number so-and-so. All parties concerned and the circle officer has attended the hearing. Sri Niranjan Deka, Madhav Gojara Kothar Purichalana Committee could not produce any approval of the state government during the hearing. So there is no approval from the government for this 8 bighas. As required as per the 4.1 of 1989, in view of the above and in pursuance of the Rule 26 of the Assam Land Revenue Manual, I am satisfied to cancel of the settlement made by who have the allotment for 8 bighas of land under Dag number 378, so-and-so, by government. So the point is, Lordship, the 8 bighas of land, government approval, 4.1 and the 26, they have power. Lordship may come to page 63. That is the type copy is at page 62, Lordship. Or I can read the original also, Lordship. I'll go by the.
What is this?
This is the government notification, Lordship. Lordship, may I start it from page 61 because the type copy is there. One by one, I'll go. Page 61, Lordship. For a minute.
Yes, you are positioning the land.
Yes. There is status order also.
We'll hear it some other.
Okay, Lordship, there's the only thing, Lordship, there's 3 order from this court. Because the one
Only
officer,
anxiety is that if you have blocked any water body.
but that is not my case, Lordship. In the order, this is not reflected. Lordship, Mahendra Singh Gill is very clear, paragraph 8, that you cannot develop the case by filing an affidavit. Now in the affidavit, paragraph 8, they say that there is some canal and all that.
No, no, not only the affidavit, there are some
There's a
documentation.
meeting and the meeting
Ha,
they have
ha,
passed.
ha.
Yes, I have seen the last page of the year. But the point is, Lordship, in the order, it is.
What
not
is
reflected.
page 58?
Yes. Page 58, last year, Lordship, serial number 13.
We'll set aside the cancellation of patta and you proceed in accordance with law.
Yes.
In accordance with law, this is not the way.
Yes.
Where is 26? So as 26 rule.
Yes, Lord. Yes, Lord. Photo making.
Assam random.
Lordship. Yes, Lordship.
Page.
Yeah,
This is rule 26 of what?
Page is 80, Lordship. No, page 80, Lord. Page 88. 80-8, Lord. Lordship, this book, Lord.
Yes, yes.
80 down below. Confirmation and cancellation subject to the general control of the state government. The commissioner shall have the power to confirm the settlement and also to cancel any settlement made in confirmation of this rule after giving the lessee holder an opportunity of being heard. Now, in our case, Lordship, now the government has all thing has sank 4.1, 8 bigger, no approval is necessary as per the land policy and all that. They have not seen anything, Lord. I have annexed all those documents. For 8 bigger, it is not necessary. Approval is not necessary. As per the land policy and the government, executive inspector. And the Lordship here in my case, Lordship, the commissioner has not passed the order. That's the whole problem. It has not gone to
Your basic case is the procedure prescribed under Rule 2626 is not followed.
Yes.
Second case is that person not authorized under law has passed this order. It ought to have been passed by a person, Nasir Ahmed, and therefore it should go. If we and there is violations of principles of national justice. So on 3 counts, if we set aside with a liberty to the government to
Follow that.
to take a phrase decision if at all grievance remains.
Yes.
That's all.
Even.
We are not entering into the merits.
Yes.
And blocking the.
That is up to you. We made it clarify. They can exercise their power even for cancellation of the settlement, eviction in terms of the procedure laid down.
The procedure. Yes. Because now they say that
We'll dictate it on
we have to
Tuesday.
take the permission of the government.
We'll dictate it on Tuesday.
Oh, Lord.
Dispose of?
Yes, yes. No problem.
That much. List this matter
This is
on
the
Tuesday
beauty
for
of
delivery of orders.
2 of us appeared and we know our case.
We are not going whether it is right, wrong. We are saying that admittedly, because the impugn order itself says that they are settled with the land. Moment it is an admitted position, a procedure is to be followed, not by taking a village meeting. It is not the procedure and not by the deputy commissioner. It should be the commissioner.
Yes.
The other part is a different cause of action that we can.
That you are saying land blockade, even without cancellation of patta, you can do that. There are many provisions.
Because of land law.
Even in the CRPC, there are provisions. Forget about others.
33 is there, Lord.
Yes. Tuesday for delivery of orders.
From morning I am sitting here, Lord, my blood pressure has gone down from 140 to 120.
Why?
Very nicely conducted, Lord. Everybody is happy.
May please your lordship, madam may pass about for time being lordship. My senior takes to put up.
Lordship, I am appearing on behalf of respondent number 5. I have been impleaded by authoritative 13, 13,
So according to them, you have not kept any boundary in the wall itself, you have raised the house.
Lordship, there are 5 respondents have been impeached, Lordship.
Ah.
I share a very small portion of the boundary.
Who are the other respondents?
I think they are not represented today, Lordship.
So what can we do? We'll ask the GMC to verify you cooperate.
Lordship, no, I have already cooperated, Lordship. I have, even in the month of January last year, I have received a notice, Lordship, from the respondent number 4.
Have you filed affidavit?
I need some time to file
Okay.
it. I
The
will bring on
learned
record
counsel for the newly imputed respondent number
5.
5, 6, 2 weeks time,
Lordship.
3 weeks time to file affidavit of issue. PR is allowed, list accordingly.
I'm deeply obliged, Lordship. Yes.
This relates to the non-payment of the contractual bills.
Yes,
work-
yes.
The work was completed, the work completion certificate was issued, but as they have not been issuing the bill.
Now, what kind of order do you expect from us?
Your Lordship,
My
there
lord,
is,
disposing of this matter will be little difficult, my lord, today. My lord, I will just.
No, just, you take your seat.
My lord,
I am asking him.
Your Lordship, there was an NIT, in process to that NIT work order was issued, I have completed the work.
No, that is fine. That is
And the
fine.
work
There is no dispute on that. You have completed the work, there is no dispute. The problem is here. If you come to page 77,
Yes, Your Lordship.
according to them, according to this Gogoi, they have verified, and instead of 3 bedrooms, for example, you have constructed only 1 bedroom. You have not constructed this way, that way, that way. You file a reply saying that no, I have done as per so and so. Now, in the backdrop, we are not commenting on whether you are right or they are right. In the aforesaid backdrop, can we pass an order even to consider your case?
Yes, sir.
What consideration they will do? They have taken their stand.
No. Once we have issued the completion certificate,
Hmm.
there was a joint verification made by the PWD as well as the commandant.
Hmm.
They have given a work completion certificate. That is the precise case, Your Lordship.
Hmm.
And that exercise was done on 4/11/2019.
Hmm.
I handed over the entire things to them.
Hmm.
I come back.
Hmm.
Now there was an order which they have not annexed.
Hmm.
They say that on 39/2000.
Where is that?
If Your Lordship takes up the.
You have
affidavit-
filed reply.
I have filed a reply also, Your Lordship.
Have you annexed that?
No. That is their statement, Your Lordship.
Uh-huh.
If Your Lordship kindly take up my writ petition, the completion report is at page 55.
What is your stand regarding completion?
That's what I'm saying, Your Lordship.
Yeah.
On 4/11/2019, the
Hmm.
work was completed. The
Hmm.
dates are very important, Your Lordship.
Hmm.
They have given the work completion certificate. I handed over the site. I come back. Now in their affidavit, they have
When work was completed?
4/11/2019.
4/11/19.
And the work completion certificate was issued to me by both the authorities on 4/11/2019. Page 51, Your Lordship, of my writ petition.
Inspection was done when?
Your Lordship, it was done on 4/11/2019, page 51, Your Lordship.
No, not that inspection. They have taken a stand that money was sanctioned, everything was done. Before release of the payment, they did an inspection, whether work is completed or not.
That they could not have done, in my humble submission.
No, they could not have done or not done. That action is not on the challenge. Here a writ petition in the simple ground that I have executed my work. Please direct to pay me
Right,
the amount.
right.
And law is well settled that writ court can exercise such direction of payment only when there is an unequivocal admission.
Right.
There is no unequivocal admission in this case.
Your
So
Lordship.
therefore, can we pass a direction?
Your Lordship, to that I'm coming. I'll just try to satisfy. I might be wrong, Your Lordship. Page 55 of my writ petition. This is the completion report.
No, that we understand.
Right. Now, this was given to me on 4/11/2019.
Hmm.
I handed over the site to them.
Hmm.
I come back.
Hmm.
Now, Your Lordship will take up the affidavit in opposition.
There
page
is no doubt
78.
that you have, therefore I am asking whether they have disputed that this was not an work completion certificate. They have not disputed.
No,
They have not disputed.
not disputed.
What their case is that, yes, this is fine. But on our own, we had a committee and we verified it. Now they found that the construction was not done as per the.
When they have done it,
Hmm.
behind my back, on 2/10/2020,
Yes, we understand.
that is more than 11 months, your lordship.
11 months. So this report was filed. We are not commenting on anything on this report.
Right.
Nothing. We are not commenting whether they are correct or not. But to say that you are entitled for the money, we will have to make a determination that this report is incorrect, and will have the respondent can have no option but to act on the completion certificate.
Right. Yeah.
Okay. Is it permissible in a judicial review?
Your lordship, in my humble submission, they say that I'll just read there, that as per the procedure of Moitra scheme, a third party's inspection is required. That was not a part of the NIT, your lordship.
Understand. Diesel again will have to come that this is not a part of Moitra's report. Therefore, they cannot insist upon this. That is what I am asking.
Your lordship,
We'll have to make this determination that you don't have a power, and the writ petition is for that I have executed the work, pay me. They said you have not executed in terms of tender. There is a requirement of third party inspection. In the third party inspection, we found that you have not executed the work. You say that I have done the work. The executing authority has given completion certificate. Is it the law that this can be treated as an admission?
I would say yes, and I would further add to it by saying that when a statutory authority passes an order, you cannot supplement it by an affidavit. And that report has not been annexed.
I think you are aware of the law laid down by the full bench or division bench in this regard, so far relating to the contractor's bill.
Right, yeah.
What should be the parameter to exercise the judicial review? Do you propose to say that in the given facts of the affidavit in opposition and reply, these parameters are satisfied? Tell us.
I would say in that way that once you have issued the completion certificate by the executing.
But that is not the mandate of the judgment. That judgment specifically, Mr. Thor, who have asked you. When court is not even arguing on your behalf, we do not want a supplement. We may change, he may convince us. That's why we are asking these questions. If we satisfy, then we'll come to you. Is that it? Take some time. This is the basic issue. If you challenge the condition itself and their decision and determination to go ahead with a third party beyond the scope, and if you can from the tender so that they don't have power, that will be a different cause of action to exercise our judicial review. No problem on that. But that we cannot do here. On the basis of affidavit and reply, subject to your further argument. That we can very well, if it didn't come within the parameter of judicial review. From the record itself, if we can have a satisfaction without any dispute, that this is the contract clause, this is the procedure laid down, there is no scope for third party. So there will be a presumption on the basis of the completion certificate that has also been given by a none other than a authority of the state. That is your case,
yes,
but we cannot decide here. Can we?
In fact, there is a drawing. We have.
Again, you are coming to the facts. Answer the law. On the prayer of the learned counsel for the petitioner matter stand sanction and be listed. It will take a paragraph to dismiss your petition. A simple paragraph. That these are the dispute. If the prayer is this, therefore this court cannot, in terms of Tomser Ali, this petition cannot be entertained because in Tomser Ali a specific mandate has been given that the admitted amount can be directed only when the head of the institution has in unequivocal ward has admitted, not even the executive engineer, head of the organization. Still, we are giving all executive engineer and ignoring. That is the law. Dismiss with a liberty to challenge.
I'll come back to your lordship.
Yes.
Item 16. In this case, my lord, affidavit opposition.
What is this case?
Barter system, my lord.
What barter system? Tell
Barter
us.
system,
We are
yes.
getting nothing here.
Yes, my lord. Myanmar barter trade to Mora Land Customs Station, Manipur barter, my lord. Trade formulated by Reserve Bank of India.
Now, who will pay you the money?
My lord, that has to be by the Reserve Bank of India.
Who is representing Reserve Bank?
Yes, my lord. Annexure 4, page
No, no, who is
47.
representing Reserve Bank?
Nobody is there.
Notice served.
Notice, my lord, deemed to be sharp, my lord. That's why they
Take a dusty service.
Yes,
Which office?
my lord. Reserve Bank.
Guwahati.
Yes, my lord. Guwahati.
If Guwahati, take a dusty service.
Yes, my lord. Regional Director, India.
Okay, respondent number?
2, my lord.
Though service upon respondent number 2 is deemed to have been served.
3, my lord. 3.
Respondent number 3. However, the response from such respondent is vital for determination of the issue raised in this writ petition. Accordingly, Mr. Das, Learned Counsel, submits that he may be permitted to take dusty service upon the respondent number 3. Prayer is allowed through registry. Notice is made returnable after 4.
All right.
And proof thereof affidavit.
Yes.
Yes.
17. 17.
Yes.
My lord, petitioner is a font that I could not hear my.
They have filed additional affidavit yesterday, lordship.
Who filed?
Petitioner.
Okay, it is stated that an addition.
Copy receipt.
Huh?
Whether filed or not, I have received. the copy.
None appears for the petitioner on all. However, in the interest of justice, matter stands adjourned and be listed on 3rd of April 2024. Interim order passed earlier shall continue till then.
Item 18 and 19.
Lordship, matter may be taken on next Wednesday.
Why? What is the
Standing counsel is out of station for his.
Who is standing counsel?
Oscar Parwa, P.
Huh?
P. Parwa.
B?
Parwa,
You are for whom?
petitioner.
Forget about him. He is not here, we will hear you. Do you have any problem? He is not present, forget about him.
So he's my senior competence for me to. He has something to submit on.
There is nothing in this petition except not allowing him to participate in other auction. The settlement is over. Subsequent settlement is done, isn't it? Tender was not interfered. Only thing is that you have been debarred from participating in other such kind of tender, whether that can be, whether that they can do it without notice. Let us decide that. This is item number 17 and give the other petition. I think 18 has become infructuous. No, 19 has become infructuous. Who is your senior?
Oscar Parwa.
Where is he?
It's out of station for
You read this file and come back at 2.
it.
Huh?
Lordship, I don't have.
This is the chance. Read the file and come back. What is your case and what is your right? What has been violated? These three matters, 3 issues is necessary to argue a writ petition. What is your case and what was your right
Lordship, the
and
file
how
is
that
not
has been violated and who violated? If you are satisfied, violated will interfere.
Lordship, the file is not read.
I'm giving you the file, a copy to study. Read it sitting in the chamber from 1:15 to 2.
What's the
I'm giving you a chance, you are not taking it. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks. Yes.
My lord, the petitioner, my lord, have filed this case, my lord, because, my lord, during construction of the road under, my lord, Pradhan Mantri Gram Sadak Yojana, so around, my lord, 15 cut-off land is included. But, my lord, they have filed an affidavit, my lord. This affidavit, they have, my lord, stated that near about, my lord, 13 cut of land has been acquired, but no compensation has been paid, my lord. No. So my humble prayer, my lord, Deputy Commissioner may decide after hearing of the petitioner. So some disputed.
Deputy Commissioner will decide what?
My lord, the Deputy Commissioner has filed the affidavit, my lord.
Deputy Commissioner has passed an award.
Yes.
No award. Award passed.
No, my lord. Has not been acquired, my lord.
Yes, madam.
Paragraph number.
Your affidavit says that some lands at page 61, paragraph 1, 2, 3,
Yes, sir.
5 shatak under 429, 8 shatak in 436.
Yes.
Then these 2. If you have taken land, then 4 shatak in Dag number 441.
4 shatak from Dag number 441
Lord,
and
no.
What
my
is
my 5 shatak from Dag number 429.
you are related to which plot?
He's claiming
My lord,
How many petitioners?
one petitioner.
What is your claim?
My claim is, my lord, near about, my lord, 15 cut-off land was acquired. As per
Not acquired.
not
Ah,
acquired.
not
I'm
acquired, my lord,
clearly-
sorry,
clearly
not acquired,
stated in
sorry,
my
my lord.
affidavit, my lord.
Non-acquired. Their case is that, what is your name? What is your Dag number? Tell us.
My lord, Dag number is 429, 436, 270 in second RS Patta number 47. And another, my lord, in same Patta, my lord,
According to them, 5 shatak currently is found to be covered under PNG Road village.
Yes.
In paragraph 2 of my writ petition, I categorically stated, my lord, and this honorable court also called for a report also from. And thereafter, lastly, my lord, they have filed affidavit.
Yes. Deputy Commissioner, who will acquire the land?
This is under PMGTY construction, my lord,
Ah.
construction. I have found the deputy commissioner, madam. Hello, I've stated in paragraph number 4, my lord.
According to you, if we could properly understand, 5 shatak under 429
Yes,
recorded in the name of Suraj Ali are used for PMGS.
yes, madam.
Okay.
Yes.
So do you is it not required to acquire that land or not required? PMGS is excluded from Land Acquisition Act.
Yes, my lord. It's
Huh?
not excluded.
PMG SY is excluded from land acquisition.
I have,
No, come to your affidavit.
yes, my lord. As per instruction, I have filed this affidavit, my lord. In affidavit, instruction. is not
Instructions
stated.
is no value after filing of the affidavit.
Yes, my lord.
That is on oath, that is on signature.
Let's page 39 is my representation, which is filed my lord especially.
We are not disposing of representation. We are not post office here.
Sure.
Understand? A citizen has come, his right admittedly on the basis of affidavit has been violated. We'll decide it. Who is Deputy Commissioner?
And the Pradhan Mantri Gram Sadag is.
So is
my
it
lord,
not applicable? Land acquisition is not applicable.
applicable, my lord?
Then if it is applicable, pay compensation, land, acquire the land.
My lord, fix it after 1 week, my lord, I'll hear.
The grievance of the petitioner is that land measuring, according to you,
15 kattha.
15 kathas have been used for construction of road under PMGSY. Land mane patta land belonging to the petitioner ne likhi diba. And no compensation has been paid to him. The respondent respondent number 5, that is Deputy Commissioner, has filed an affidavit. A specific stand has been taken that 5 sataks of land under DAG number 429 is recorded in the name of the father of the petitioner. You are Suraj Ali?
Yes. No, I am the my lord Saira Begum. My father is
Your father is?
Suraj.
Name of the father of the petitioner, Suraj Ali.
And 8 Chatak from Dag number
And
430.
same is under occupation of the petitioner. Another plot of land measuring 8 shatak under DAG number 436 recorded in the name of the father of the petitioner along with others, along with some joint owners under occupation of the petitioner has also been included in PMGSY. Full stop. Full stop. Thus, a plot of land measuring, thus, if that be the stand, if that be the stand, such action of the respondent is suggestive of an action violating the petitioner's valuable right without following due process of law. At this stage, MS P.R. Mohanto, learned counsel representing for respondent number 5, submits that she will obtain instruction from the Deputy Commissioner as to how the Deputy Commissioner and the state authorities implementing PMGSY are proposing to compensate the landowners, not the petitioners, because she is not the only owner. The landowners under DAG number 429 and DAG number 436 of which out of 436 for using land measuring 5 sataks and 8 sataks respectively. Prayer is allowed. Please this matter on.
First week of April, my
Not first week, we are giving some more time. Give the details who are the others. Because moment we pass an order to consider his case,
Yes.
his case will be considered. That's why we are not disposing of even his insistence. He is insisting, send it to Deputy Commissioner in view of the admission. Deputy Commissioner will give everything to the petitioner. That land belongs to the father of the petitioner, Esmali Patta. And again, there will be reference. Isn't it? That's why you want a shortcut to go to the deputy commissioner.
And that,
We also know little bit. That's why we are not allowing. It
No,
would have
that-
been the easiest way dispose of.
because
We'll
my
not
lord,
do that.
only-
Let's this matter on. We understand. Let's this matter on. 25th of April.
Oblige.
Item 21 and 20. Item 21 and 24.
Give the other matters. 21, I will take little bit later.
For Lordship 22 to 24.
22, 23, 24.
Lordship may kindly take, have a look of the order dated 10/1/2024, wherein it was, we prayed for segregating those two from 21. So these matters can be disposed of in terms of the Tamsir Lordship, I am similar order also.
Terms of
Terms of Tamsir Lord.
No.
8 GLT.
that we are not going to do.
Because a series of cases were disposed of.
That we are not going to do.
Okay.
We will have to have a first satisfaction that it is covered by Tamsir Ali.
Lord.
Then only we'll ask for verification. Yes.
That, so far as this
These
case,
3 writ petitions be segregated from WPC 3478/2022. Full stop. The petitioner is before this court seeking a direction to the respondents to pay an amount of rupees 10 lakhs,
Lord.
comma,
10 lakhs already paid and remaining 10.
an amount of rupees 10 lakhs as outstanding due for execution of certain public work under the respondent authorities. The Learned Standing Council for the BTC submits that he will obtain instruction whether the petitioner has executed the work as claimed and entitled for the aforesaid amount of rupees 10 lakhs. And if so, the reason for non-payment thereof. Prayer is allowed. List this matter on 3rd week of April.
8 week.
3rd April. 3rd of April. 24th. Give the other item. Yes, what to be done here?
Your Lordship, the amount is 15 lakhs. All.
Which?
In
Second
item
is
number
15 lakhs. Then
23.
give the list. That is over.
Lordship,
There's 3 matters are over. Give the numbers and the amount.
Lordship.
Now come to this item number 21.
my lord, as far as this item is concerned, I also made mention
Huh?
this morning. My
Huh,
lord,
huh,
the instruction was received last evening only.
You want to file affidavit. Okay, Mr. The Learned Standing Council for the BTC, Mr. S.R. Rava, submits that he has received instruction and requires 2 weeks time to file affidavit. Prayer is allowed. List accordingly.
Item 25.
Yes, Mr. Rava.
The affidavit has been filed, my lord. And it is,
May I please, your lordship, my senior is on Lexington Court 18, lordship. Timing may be given.
let it be some other day, my lord.
Okay. Affidavit file. You want to, you will not file reply. Okay, it is submitted that the Learned Council for the petitioner is having some personal difficulty. Accordingly, a prayer for adjournment is made. Prayer is stands allowed. List this matter. Give a 3rd week date, April. (22nd of April, 2024). Interim order passed earlier shall continue.
Like,
In the meantime.
Item 26.
Yes.
May please, Mr.
Hmm.
Record regarding award was called for last.
Yes. Yes. Yes, what is the claim here?
Claim regarding my lord, land was my lord acquired my lord
Hmm.
by the AID, by the Deputy Commissioner my lord,
Hmm.
to my lord construct my lord, AIDC, AID.
Hmm.
Petitioner my lord, petitioner seeking your lordship my lord, possessing the land my lord since 1980 my lord. They purchased the land from the.
Who are the private respondents?
I am lordship for respondent number 6 and 7.
The amount has been paid to you
No, but this state, award has been in our
in your
favor.
favor.
We are the
Now,
owners.
did you claim
Yes,
before
madam.
the deputy commissioner?
Yes, madam, we filed
Now,
a-
how will you decide? It will be decided by the reference course.
Yes, ma'am. That is my prayer. Deputy Commissioner rejected my. They are not person interested. That has been.
Who will decide that? Who will decide that who their person interested or not under the act?
That has been already been decided by the commissioner in its.
No, deputy commissioner has decided that has been alleged to be bad. Now, for who is the authority to decide who is the less interested or not?
That is the procedure to lay down in the reference.
Then
Has to go to the reference.
Reference
There is one my anxiety lordship. 64 reference is 139, section 64 reference. It says any person interested who has not accepted the award. So I am emphasizing on the word accepted. So
So
acceptance
according
also-
to you, except the person who is aggrieved by the award so far relating to the quantum or acceptance or non-acceptance, only reference is material. What will be apportionment? What will be the claim? So according to you, suppose it is admitted there are 4 brothers.
Yes.
They are claiming that apportionment should be in this proportion. Deputy Commissioner could not decide. Now, then in terms of this, that cannot be a reference.
No, it is there. Lordship. By written application to the collector required that the matter may be referred to the collector for the determination of the authority.
Okay, we'll take up this. This will take some time. We'll take up today itself after some time. Next second half. Be ready. Next.
Item 27.
This is the dispute regarding land miller. We have found that grandfather had some partial land miller.
Hmm.
That land miller is eroded by river also miller. Now it is again miller simply. Sure.
Main order.
So when the land is now fit miller, the government has filed a fit miller by which they are saying that yes, it is now we are using the land. But Patta is not eating, our name is also corrected in the same land. That is
Yes, I'm not getting anything. What is your grievance?
my land is there in great grandfather miller. Our name should be correct. That is our whole thing.
What is their stand?
Just similar, their land is government land now. Earlier it was Patta land. Now, it is
Now, how they have converted as a government land?
no procedure, no nothing. Anything.
No, affidavit?
On affidavit is filed, yes.
No. What is your stand in the affidavit?
There is only the government land, so we have no authority. And some portion is now.
No,
so
they have, according to you, they have admitted that it was earlier in your name,
My lord.
your father's name, but
It is
now
their
it is a,
name, father.
but it is a government land.
Yeah.
This is fine, no doubt about it. Now, is there any stand that how it was converted, under what circumstances?
No,
That we must know.
That's silent.
That we must know who. Yes, government.
Well, for latest affidavit, it is not admitted that it was earlier in their name. It is purely government land.
No. What was the history of that land? It is government immemorial? Or it was, where is that paragraph?
My lord, page
First
71.
tell us, are you ready to argue this matter?
My lord, maybe some.
Have you read your brief?
Not some other day, my lord.
Till
We
that.
have filed our affidavit.
Till that, don't waste time. Learned, why this IA is filed?
IA is filed, as we go, they have filed affidavit by which saying that our land is going to be allotted with some other person. So I have prayed that the allotment should not be there. Maybe state here.
Okay, the Learned counsel, in a minute, learned counsel for the respondent, prays for some time to address this court in this writ petition. Mr. Next figure, Mr. Where is the stand?
Page 71, my lord. In our
Yes.
71. Paragraph 3.
Come on, please stop. কি করলো প্রথমখিনি পাহৰিলে the present the petitioner is aggrieved for the reason that according to them without due process of law their patta land has been converted into government land. Full stop. The government has taken a stand that the land is recorded as government land alongside riverside reservation within bracket Gorabad, comma. Full stop. Where is the statement that they will settle?
I have an kindly similar paragraph, annexer also similar,
Page?
in my petition, my lord, annexer,
Okay, at 2.
page 6, my lord, paragraph 2 of my IM, my lord, 3414.
Against that, Lordship, we have, in IA, we have filed affidavit to Lordship, may kindly peruse, Lordship. Kindly, paragraph 4, Lordship. Our paragraph 4, Lordship.
My 2, my lord, 2 and 3. That the applicant stated that the land in question was married land and April, my lord, kindly see, only one thing, last, my lord, on annexer, my lord. Annexer A, page 10 of my IM, my lord. Similar, some land in our land, my lord, they are, my lord, now proposed to, my lord, allowed to some other person, they are not known to us even, my lord, and then not in possession of the land, my lord.
So, Lordship, may paragraph 4, Lordship, may kindly.
Proposal for allotment 10.
I, Lordship, paragraph 4, Lordship. This file, Lordship, on 1912, it was filed. It was filed, Lordship, may kindly peruse. That I can do. Probably, Lordship, it is come not file, Lordship, may just peruse it, Lordship. No, that number 3. Is Lordship. Probably it was not filed also, Lordship, it is there in the. Paragraph 4. No, no. No, to my heading. Against the reply of the I. It's rejected. Lordship. 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 That cannot be, Lordship. That cannot be. Even also, Lordship, that was come in the affidavit. Lordship.
And my lord, this is our original part, of course, my lord, could not skip. This is the original part, my lord. Saraji part number 44, and name of the person, my lord. And till that, we are holding and positioning. Even they have stated in their affidavit, and also by annexer, my lord. Correct. No. File me. I received. I have had. File me.
Any deal of otherwise pleading is completed. Lost the plot.
March Miller.
Appeal.
One thing, Miller, IA number, Miller, that is fully wrong. 3414, not 2669. IA number 3414.
May appeal. Not as per section 64, my lord. Deputy Commissioner is required to, my lord, refer the matter to the authority matter. Kindly see section 64, my lord. Under the Assam land, my lord. Yes. 13 Act. Now, under this side, it was acquired on, my lord. LN number 5/21, my lord. Section 12, my lord.
Lordship, no. They are claiming they should also get the award. It was not in their favor because they are not person interested. Now, as per the 2013 Act, section 64, who can apply for referral? Except for exception, there should be an offer. There should be an award. Award in my favor. If there is an award in my favor, I may not accept it, and on protest I can receive it, and they have no civil court lordship. They are disputing with us. We are the owner of the land. They are saying they are possessing it, and their claim is lordship, they have annexed a unregistered sale deed. It is not admitted that they are personally interested. It is disputed. They have made an application before the deputy commissioner. It was not, there is no admission that they are personally interested. That's why lordship, their remedy to prove that they are either occupier or title holder something, civil court. Yes. Lordship. Because yes, 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 yes. I'm interested. Not only notice, not only notice. If we can show that this name is muted, name is there in the no, it's a prima facie. It is. It is not the no decision is required. Prima facie. No, apparently their name is not there. So reference code cannot declare. Can lordship reference code decide title or possession? My humble submission, reference code cannot lordship. Reference code cannot decide title. Their remedy is before civil code. My humble submission is their remedy is civil code to prove their title or possession, whatever it is. Right now, I cannot have authority. Civil code is section 63 matter. Section 63 matter. Because (76) and if 76 also 77. Yes, lordship. I have gone to this. It is personal interested means whose name is recorded as the owner of the land or building or part thereof in the records of the authority concerned. Yes. Mutation, yes, mutation holding, etc. Any person who is granted forest rights under the scheduled tribes and other traditional forest dwellers recognition of the forest right act is not. Yes. Who is entitled to be granted patta right on the land under any law of the state, including assigned land. Any person who has been declared as such by an order of the court or authority. It is not government land, Lordship. It is not government land. It is our.
Yes, only 64. Reference to the authority. Any person interstate who has not accepted the award may, by written application to the collector, request that the matter may be referred by the collector for the determination of the authority, as the case may be, whether his objection to be to the measurement of the land, the amount of the compensation, the person to whom it is payable. That is my case. The person to whom it is payable. That thing should be decided by the my lord, the authority. Notice is not with me. Notice is. But we have filed application, my lord. Thereafter notice is there. That notice is there. After filing objection, the notice was issued, my lord, to us. Page 42, my lord.
Yes. Yes. 5. Lot. Yes. Lot. This is. Page 42, my lord. This is, my lord, page 39. Amir Hussain is the, my lord, original owner. They are, my lord, our father.
in the year 1980, my lord. With the-
My view is, my lord, it has to be open. Because both the sections.
There are orders
And
also.
76 also.
Orders also there. Of this honorable court, my lord. High Court of Himachal Pradesh, my lord. Regarding 64, my lord. That- in Guwahati High Court case, my lord, they challenge the award, my lord. That is not there. That is not there.
It is a lot. Also, in this case, no affidavit has been filed by the respondent. Okay, already we have approached before the district commissioner lordship, but till today my defense has not been referred to the reference court. Lordship, as per section 12 of the Assam Land and Acquisition Act, lordship, my defense has been referred to the reference court. I have already approached before the district commissioner. Lordship. Yes. Lordship, till today my representation have not been disposed of. Yes, Lordship. Yes, Lordship. Yes, Lordship. In this case, Lordship, reference to court. Lordship, the collector shall in every case, Lordship, subsection A, where any person aggrieved by an award made under subsection 3 of section 11 make. Yes, sir. Yes. Wrongly determined. Yes, sir. Lordship, before filing this, we have filed representation, but actually I have no, my representation have taken any step, Lordship. Yes, sir. Yes, sir. Yes, Lordship. Lordship, kindly allow us some time. Sixty-four. Yes.
Service completed. Service has been. The service is completed. No service. No, nobody has appeared. I think. Amber. Hmm? Service is complete. As per the last order, service is complete as on 28 to 2024 last order. Or Niara is there, is a private company, but this guideline norms is binding because this is not only a guideline, it is a statutory force under an act, So this is become a guideline is enforceable, enforced. Yeah, that's what under 28 of this act. My so we made a party private. They are not appearing. NHS. Then that's very important. That's the whole issue. National highways. Yes, it's a national highway. But there are provision, I have seen national highway. Suppose you want to establish something, dhaba or a petrol pump, you have to take permission. They will give the license fee has to be paid. Then only you can set up. Clear.
Again, on behalf of Water Resource Department, we need some time to file our affidavit. Few weeks time. Right.
41 lakh. Lordship, already after receiving the bills, it has been sent to the sanctioning authority to approve the amount and give. But that has been done long time back. But yeah, I have one instruction. But after going through, definitely they can dispose of. They admitted the amount. They issued. That's it. Yes. Yes, present file looking. Started. sanctioning authority, police headquarters. Assam police headquarters. Three weeks. Date may be fixed. Does it, can it be 3 weeks? Any date. Yeah. No, pilot, then can we dispose of it? Yes. My lord, there's all issues, my lord, here. Only, yes. That lordship already disposed of all such matters, my lord, on the basis of the policy of the government. Yes, yes, I have enclosed, my lord, at page 34.5, my lord. The present petitioner is a father, my lord, father of the deceased. Yes. Due to vehicle accident, my lord, on, yes. On 10/1, the accident was occurred, my lord, and 10/1/2022. And the person died on, no, 10/1 accident was occurred, and he was taken to hospital on 19/2/2022. 2022. Lord, and FIR, yes, previous. The FIR was lost on 8/2. Yes. On 10/1/22. 8/2/2022. At Bokakhat PS case number 22/2000. PS case number 22 of 279 /339 /304A IP. Then Lordship will find the government notification 15/11/2014, my lord, and there is a representation. The another was also same. Next, 33. Hey, Lord. Yes, yes, just my lord. Yes. Yes, I will.
Okay, I'm asking for 3 weeks time to file our reply. They have filed their
My lord. Yes. On. Yes. Well, it has been kept in abeyance, not prosecuted as of now. Yes, but speaking order, my lord, we have annexed, ma'am. The speaking order of the
reply. Lordship, there is an interim order that
after PO.
may be confused.
By that time, my lord, they may file the highly obliged.
May I put your lordship may take up WBC 6760 your lordship. Lord. That I will have to leave. I will have to leave your lordship. To your lordship is this lord. Award, it's a award passed to private negotiation, your lord, under section 46. 50% paid. Now there is some complaint. They resurveyed it and they keeping it whole, saying that ultimately they want to your lord. And there is no power, no affidavit.
If the reassessment has found huge anomalies as regard difference in the amount that has been calculated prior and the present. So hello. Yes. No.
No.
It's a deal. It's a deal. Yes.
Yes. It's an award, your lord. Word used is award. Your lord. Then it will lord.
The previous. No. Access or either to read.
If they feel your lordship, they can go for recovery by filing suit, your lord. No, your lordship, that they can, your lordship will kindly see one judgment I am provide submit. This deals with the issue, your lordship. Of FX, your lord, 2019 9 of 60, your lord. It says when there is no power of express power of review, then it cannot be. Para 8 to 14, your lord. In fact, your lordship, even for clerical mistake, your lordship, time is for 6 months, your lordship, not beyond that. There is no provision under Land Acquisition Act 1994 review of the award once passed under. This is related parameteria provision of 1894 Act. And the only provision for correction of clerical errors in the award which is provided for under section 13A of the Act, which was inserted with effect from so and so. The relevant section 13A of the Act reads as under. A bare reading of the section 13A would make it clear that the same is not a provision for review of the award but on.
I want some time.
Lord.
Next week. Next week.
Lord. Thursday. Lord. Friday. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
20.
Section 46. Deeply applied. Okay. Same here, same.
May I please? Lord, we have considered this case and we found that ultimately when the liability is to be satisfied by the company, we have taken approval from the higher up and we are set. But already we have taken everything has been processed, only if you no. I just tried because I overheard that the petitioner family is suffering from cancer. So I intervened.
My lord, regarding that, my lord, yes. That's but my lord, I have only that this experience was occurred in 2015, my lord. Now, in my lord, let's see. That's true. That's yes.
My lord, only problem we will be facing is, my lord, we were not in the trial court and we don't have any document.
My lord, how?
My lord, this I downloaded from the website of Axis Bank. These are the documents required while settling the claim. These document either they give or they give or any one of them.
Your lordship, that we are under nothing, your lordship.
No, my lord. What
Nothing,
happened, my
your
lord?
lordship?
Let me need
No, your lordship, it is not that we do not want to help the court. But what was only one submission, your lordship. Only one submission. That is, your lordship, that they have to file their claim before the. Yes. Yes. Your lordship.
My lord, I have seen the documents, my lord. But some documents I have, my lord, but some documents is not with me.
Lord, I have just given a copy of this.
Yeah.
List
My lord,
also.
for a moment, my lord, kindly the debit card is not with us, my lord. As because my lord, and but death certificate we have, my lord. FIR copy also I have, my lord. And my lord, postmortem copy is not with us.
That is the
But my
important
lord,
document.
whatever actually, my lord, all those things were deposited before the Axis Bank, my lord, in the earlier occasion. And after that, my lord, that Axis Bank released that, my lord, balance amount as per the direction of this honorable civil case, my lord. Now, no documents with me, and that is an old lady, my lord. I have talked to them also.
the basis of the only copy of only death certificate has been deposited.
Two. In Prastuti Mia, response number 3, the other matter, insurance company.
And it will minus 22.
No, let it be depicted 28 already.
In the meantime, if I'll try to my oblige.
Tell you.
Make it a lot. Okay. Case has been listed at our instance, but lordship is the order dated 17/11, my lord. But initially, when we filed the writ petition, my lord, we had challenged the inclusion of our land in the under the 2000 Act, Guwahati Water Bodies Act, saying that it's not a water body. Lord, we can't be left with a Miyadi land being a water body. Then, Lord, during the pendency, the government decided that they will acquire that land. And Lord, since it's of a permanent nature, they come up with a notification under section 3 of the land acquisition and acquisition. Yes. Lord, basically now the execution proceedings could be brought to its logical end. Lord. That
My lord, I'm on the other thing. My lord, I have also filed a writ petition regarding the same issue, and I am I am 22 members of this society, for which my line friend is appearing. I have some grievances against the government. No. He is the society.
I'm the
Yes. I am the members. Members.
He's part of me.
No, my apprehension there that the society will take away. He will take away everything. Exactly, man. And in fact, two suits are pending before the civil court.
And my lord, today my matter is not had been listed. That is, there.
Hello?
I'll give the list.
But after Lord, because Lord, Lord, since Lord, my members are Lord going day by day. The numbers are
Where there are?
only few of them.
No,
Out
my
of
lord.
300,
22 and
Lord,
11.
out of 300, they are 22
And 11.
and 11. No, Lord, so water body, Lord, vacant land.
Now he is coming. Now he is.
Yeah. No, Lord, under the act, therefore they are acquiring it, Lord. Otherwise, my challenge is. Lord, in that proceeding only, Lord, this development has taken place, my Lord.
My lord, this state petition has not been listed today.
Lordship would see, the government should say, Lord, what is the stage of the process? No, Lord, the government should indicate to your Lordship and ask us from.
Notification has already been issued. Newspaper notification has.
My implement was rejected. I filed a press lead petition, madam. I'm
Yes.
the builder. I have invested everything I had. No, my lord. I have already made the investment that I had to make by putting up the walls and everything, the boundaries and everything. But that is pending. But unless I am also here, my lord, our apprehension, he takes away everything.
Lord, he is keeping a watch being tagged along with me, Lord.
He is taking away everything, my lord.
Yes, my Lord.
All the power of attorney with me, everything with me. He makes a claim.
Lord, Lord, only, Lord, only, my Lord, only if you have the cake, we can eat it, my Lord.
Then cake has to be distributed. That cake has to be distributed equally.
My government is in the preparation of that cake, my Lord. We are not aware, my Lord, how it's been baked, my Lord. That's the issue. But he has a remedy of arbitration. Lord, let the government, Lord,
Newspaper notification is as per paper of 2nd of February 2020. Now, that
Lord, that estimation and
My lord, in fact,
They are not.
we have filed our objection before the DC, my lord. That is pending since November. Exactly. They have not done it. Nothing. We'll bring on record, my lord. This is our objection. Yes, ma'am.
at least the process should come to a logical end, Lord. One.
which one has already been published.
64.
64. That issue.
Actually, Lord, if your Lordship see the proviso that will come into play, our Vivan was first they issue under 3, knowing it, Lord, it is of a permanent nature. But that has already been recorded in last order.
Earlier order.
It is recorded. But again, it can be pursued under 3, Lord, because under subsection 3.
On 2nd of February 2000.
Deputy Commissioner.
You have filed an objection, huh? Well, I have also filed. You have also
On 27 November 2023.
Yes, I will be the distributor, my lord, if at all they want. No, we have different objective. No, we are building a, rather our objective was to build a housing colony for the members. No. It has stuck up this.
My lord, in fact,
But that would be in a different realm of things. my lord. No, my lord, we want that to work out.
obliged.
Can I play for a free state?
I will.
What?
Obliged.
Yes, yes, that I understand.
Obliged.
Keep going. My lord, in this case, my lord, last occasion, my lord, my lord, in this case, my lord, last occasion, my lord, government, my lord, direct to government, my lord, file an affidavit, my lord, in regards to, my lord, the property of a municipal property, my lord, that my lord, transfer, my lord, direct to government, my lord.
Only now I have got a communication saying that already the Director of Municipal Administration, they have written to the Longkao Executive Officer Longkao.
Happy Zolo. So this is a case for wrongful disbursement of the compensatory amount. What happened, my lord, the compensatory amount, number 5, my lord. Yes. My lord, actually what happened, my lord, I have to pay for the two land has been acquired, my lord. One land, tag number is 1671. In that case, in that land, my lord, the compensation in respondent number 5, my lord. 5,07,000. His name has been shown, my lord. Name is shown, my lord. Yes. J. Hussain. J. Hussain. J. My lord, that is actually chilling land, my lord. We are entitled for the Jidat. The Jidat amount is fixed by the authority 5,07,022 for the land covered by tag number 1671 and 45. Yes. All. Yes. Hello, I have another pair that the land in respect of the tag number 1676, that amount has not been disbursed. That could not be released. That was observed by the last officer by your lordship. This is a very small amount, my lord, 45,693. Last order, lordship's order. In the same time, paid for the same for no disbursement of the land in respect. My same pair is that.
Obliged. It may be. I look at it. Date may be fixed is possible after obliged.
Meet the your lordship, here is I am for my lord paying of an eviction notice, your lord. But my lord, the fact is that we have already been evicted. We were living in that particular plot of land for the past 50 years. Actually, when the writ petition was filed, since 1971 we were there. And
My lord, I am for a private respondent that I file a PIL. Yes. Yes.
my lord, what happened initially when I filed the writ petition, my lord? Yes, my lord, first thing.
Yes.
Compensated or rehabilitated, my lord. Yes. Lord, because since this is a subsequent development after filing of the writ petition, I have, your lordship, after eviction, I filed it after 1 day of the eviction, the IAM, and I said that I'm still in possession because I was in possession for the last 50 years. Lordship. Lordship. Yes, people. I filed it before the deputy commissioner also after eviction for my visa.
That can be
that
considered by the DC, my lord.
Your lordship. My lordship.
My-
Private.
Yes, that is the remedy. Yes. Issue will be, your lordship, suggestion second remedy is good. They can go for a filing press petition.
If your lordship
Yes.
If your lordship permits, can this your lordship direct disposal of this, your lordship, giving us liberty to come back and then we'll bring in all the policies. that will also be like filing a fresh petition. But we'll also have an option before the. But for subsequent developments, I have brought a judgment.
Şimdi tadminen in the PI. Minor. So there is evicted. Yes. Yes. Oh. Any order, my lord, that I need?
Till today, we have no any information whether my application was considered or not by the deputy commissioner. No, we have made application for. So we have submitted for representation for seeking reference to the court, also. But till today, we have no any information whether my application, our application were considered or not. So the deputy commissioner will kindly. Look, Annexure 7, Lordship, page number 45. Lordship. On Lordship 11/8/20.
Then the refer that and the government. The- But in any case, this matter ought not to have been before the court. Yeah. Yeah.
Yes, Lord.
That then and there. Yes. But then and there, that application could have been disposed of by that application. A matter in long time. The government will have no. From the government. That personal responsibility will come. We have been seeing, yes, many cases. Yes.
Lordship, 11/8/2022. Two representation, Lordship. One is 11/8 and another is 12/8. 12/8. 2020. 2020.
Correct. Correct. Friday. I will. Hmm. Yeah.
Boleh.
Lord, 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 Lord. Lord, Lord. Amended petition. Lord, full file. Lord. No, no, we are in touch. Then full. Lord. Lord. Aditya.
This morning, my lord, I was talking about a map, my lord. My suggestion is that this is not a scheme under the GMC. So we have prepared a map, my lord. In the left hand side, in the northern side is the person where the drain has been constructed. And then in the right hand side, when this is that is the southern side, proposed drain is not been constructed. And those yellow portions respondent side in the left-hand side in the northern portion. So this yellow part, they are the petitioners. They objected that way. Drain should be constructed. They want that other left in the opposite side, in the northern side, drain has been constructed. They want that it should be joined with the no.
No, my lord, they want
respondents
on the northern side drain, they want to join to outlet. Where there is no outlet.
There is no, even there is no outlet of those northern side drain. They have just constructed that drain on the northern side.
Your Honor, I have submitted my this thing affidavit in the miss case, and I adopt that I have already stated there. This I have not annexed there. If the lordship permits, I can make an additional affidavit and I can submit it. Yes, my. Yes.
You should annex the colored one. Colored.
Yes, I will annex that.
No, this is not my map. This is the respondent.
This is Dhupulia Byland 1. Yes, 3 only. No, my lord, it is a proposed drain.
Not
They have already given the land that there the drain will be constructed. That is why it is proposed. Yes. On the southern side. Byland. Yes. Yes. This is the yes. Yes. On the northern side of the road. Yes. And for the private respondent number 10 to 15. Deep. Yes.
I'm going to copy produce with the respondent.
Yes. Yes. Yes.
Sorry to barge like this, Your Lordship, in the other item before Your Lordship had said that no objection has been. Your Lordship would not write that, kindly not place that, because I don't have such instructions from the department, neither from the Deputy Commissioner, Lordship. It will be hard on my part. Later on, I would be held guilty, Your Lordship, and things will become bad for me. I'm obliged. Yes, Your Lordship. Yes. Because I'm not instructed, that's why I prayed, Your Lordship. No, this